petition item number 36, Lord. Because in this matter, notice has not been issued. It has been wrongly listed for admission. It should come up in motion. 36. May I pray that can it be taken up on Wednesday for motion, Lord?
We take it up today.
Today, I am led by Senior Counsel Mr. I. Chaudhary. He is out of town today.
Item 36 be listed on Wednesday as prayed for by Mr. S. Vishwakarma
For motions, Lord.
for motions.
May I please, Your Lordship, with the consent of other side, Lordship, I beg to mention item number 17 and 18, Lordship. In this matter, we have to file our affidavit, Lordship. We are awaiting some instructions, Lordship. I've taken the consent.
Petitioner, Lordship. A fixed date may be given, Lordship.
For what purpose?
Lordship, it is a 2019 matter. They haven't
It's
filed.
fixed today. You are agreeing to an adjournment.
Lordship, because they have to file affidavit.
You are agreeing to an adjournment. So don't pray for a fixed date.
Lordship.
At the request of learned counsels, appearing for the respondents, matter stands adjourned for 2 weeks,
Lordship, at least 3 weeks.
3 weeks to file their affidavit.
Lord.
MS so-and-so appears for the
Exactly,
petition.
Lordship.
Petitioner.
Obliged.
List after 3 weeks.
Obliged.
7 November may be given, Lordship.
What is the point in giving a fixed date? Fixed date means the matter needs to be taken up. It was fixed today.
Obliged, Lordship.
Yes.
Lord, may I interrupt? In item number 36, there was an interim till today.
Whatever is there. Don't worry about it. We'll
Obliged.
continue. Yes.
May I please, my lord? Also, I'd like to mention a matter I for impediment, my lord, in connection with item number 33 listed today, my lord, before my lord. That I may be listed today, my lord, taken up today, my lord.
Item number
33 in connection with 33.
33.
My lord, so I filed an application for
IA.
impediment.
You have filed an IA.
My lord.
Bring it on record.
My lord, I'm deeply obliged.
May it please, Your Lordship.
Your Lordship.
Lordship, I beg to mention item number 11, Lordship. Lordship, we had filed an objection against the IA, which is filed on yesterday. Lordship, record may be.
Then it will come up next week. Come up next week. Let the matter come up. We'll pass some orders. You wait for the matter to be called up. You wait for the matter to be called up.
Your Lordship, I beg to mention item number 33. Your Lordship, this is a civil bench for relating matter. But wrongly
Some mention
listed-
was made for the application.
Yeah.
Want to mention for it.
This matter is relating to a settlement of a ferry service.
My lord is taking the bench for matter.
Yes, for today, yes. For today, yes. We'll see.
May it please, Your Lordship. I am praying for listing a case of arbitration petition. Lordship, there is an urgency in the matter. So
Today,
no, for the coming week.
coming week, you mentioned in the regular bench.
Okay, Lord. I'm okay.
Wait.
Yes. Mr. Dhor, any
Hello.
updates?
My lord, on the last occasion, I placed an instruction. My lord, we need further time, my lord. It's not complete yet. That service book, they are again reconstructing, my lord. It will take some time, my lord. Last night, I talked about
Do it within 4 weeks.
within 4 weeks, my lord. Because
Do it within 4 weeks.
everything is, there is nothing, my lord. From scratch, we are just.
Whatever it is, do it within 4 weeks.
My lord,
Because it is only for the purpose of
purpose
pension.
of this. My lord will direct 4 weeks and may dispose also. Then 4 weeks.
You do it within 4 weeks.
Fine.
Let us keep this matter pending for
No problem.
another 4 weeks. Mr. R. Dhor, learned counsel appearing for the PWD department, submits that the process of reconstruction of the service book is currently being carried on by the department. However, some further time is necessary. MS B. Chaudhary, learned amicus curiae, appears in the matter today. Considering the prayer made, that the matter be listed again after 4 weeks.
My lord will just
By
indicate
which
that
time it is expected that the service book is required to be prepared in respect of the petitioner. The process for preparing the service book as required to be prepared for the petitioner is completed.
my lord. They will do, my lord.
List after 4 weeks, give a date after 4 weeks. Yes,
Lordship, in this case, the petitioner is the provider of the wholesale lordship and having state license, having GST registration lordship. And he obtained insurance lordship under the SBI General Insurance Company lordship. By policy number so and so dated 21/2/2021, covering the life
Insurance
and
cover.
the
yes.
amount of rupees 20 lakh. lordship. Subsequently, the lordship Annexure 1, page 14, lordship, the policy of the insurance lordship.
So where is your claim?
My claim is 20 lakh. lordship.
Where have you made it?
Before lordship, I filed it before ombudsman lordship and the learned congressman. After perusal of the
Rejected.
not rejected lordship, 4,28,000.
What is your claim?
My claim is 20 lakh. lordship.
It heard learned counsel for the parties. This writ petition is filed by the petitioner challenging the order dated
24/2.
24/2/2023 passed by the insurance ombudsman party in respect of the claim of the petitioner. Stop. The claim of the petitioner was for 20 lakhs against damage of the property due to fire.
Fire.
Whereas the ombudsman, after consideration, after hearing the matter and after consideration of the relevant materials, directed the amount payable to be 428,396. Stop. Being aggrieved, the present writ petition is being filed, seeking a direction that the amount claimed for by the petitioner ought to have been considered and directed to be paid by the ombudsman. Stop. It is submitted that the ombudsman did not consider the relevant materials and considered materials which are not relevant for the purposes of deciding the claim. And thereby, he passed the impugned order. Accordingly, let notice be issued, returnable 4 weeks. Steps on respondents by registered post AD within 1 week from today. List after 4 weeks.
I have this lordship. My lord, this writ petition pertains to non-payment of contractual bill and an admitted amount of rupees 6,12,166. Out of which the respondent
Yes, who-
already released. lordship.
PWD.
Yes, lordship.
This is PWD.
Yes, Lordship, PWD.
You are appearing for PWD?
Yes, Lord.
Yes. Do you admit the amount?
Actually, in that part, I will have to take instruction. The admitted Lordship may dispose of them.
Is it admitted?
Admitted?
Yes, lordship.
Where is the communication by which it is shown to be admitted?
On the representation, Lordship.
Lordship, annexure
Heard
9 and 10.
All right, heard learned counsels for the parties. This petition is filed by the petitioner aggrieved by non-payment of works completed. The petitioner was allotted the so-and-so work and pursuant to which he duly completed the works, executed the works allotted and submitted his bills. Stop. The bills which were referred to, where the bids which were raised remained pending, and the part amount of rupees 3 lakhs was released, whereas the remaining amount of, what is the remaining amount? 3 lakhs 12,000.
12,166.
312,166 remain pending. Representations filed before the authorities did not evoke any response. Under such circumstances, left with no alternative, the petitioner has come before this court. The MS Swenso appears for the PWD department. Stop having heard learned counsels, and upon perusal of the pleadings on record, it is seen that there is a completion certificate issued by the executive engineer PWD, Udalguri, R&B division, Udalguri, page number 32, in which the amount, the work has been shown to be completed. The outstanding, the amount paid and the outstanding amount required to be paid is clearly reflected. Details of works executed is also reflected. Verification, the said completion certificate is also accompanied by a verification report by the executive engineer. Under such circumstances, this court finds that the claim of the petitioner being kept pending is without justifiable reasons. Accordingly, writ petition stands disposed of with the direction to the, who is to pay? Direction to the chief engineer.
Chief engineer.
Respondent number 2 will look into the grievances of the petitioner, cause necessary verifications, thereafter take steps as expeditiously as possible for release of the outstanding amounts required to be paid, claimed to be pending and required to be paid by the department. This is covered by Tom Serali.
Yes, Lordship, maybe it's covered by Tom Sarah.
The process laid down by this court in Tom Serali is to be followed by looking into the claims and releasing the payments for the petitioner if found payable. Writ petition stands disposed of. Terms of the above. The entire exercise should be completed within a period of 120 days from the date of receipt of a certified copy of this order.
Obliged.
Disposed.
Lord, in this case, my lord, pursuant to NIT, my lord, dated my lord 19/9/22, allotment order was given to us, my lord, on 7/11/22. And during the pendency, my lord, when I my lord, during the pendency of my settlement order, my lord, as they did not, my lord, demarcate us me the area.
When was the settlement issued?
Yes, my lord. Settlement order was issued on 7/11/22, page 19, my lord.
7/11.
Yes, my lord, page 19.
So you have been running the fishery.
Yes, my lord. During the pendency, my lord, as they did not demarcate the proper area, they have published another NIT. And our representation is pending, my lord, to demarcate the state area, my lord. Kindly peruse your lordship. Annexure
What is the name of the fishery?
Kharsutha, my lord.
Okay, then
Then, my lord, this NIT amount also deposited, my lord. The first amount has to be deposited 5,13,375 rupees. I have deposited page 20, my lord. 20. First installment, my lord.
yes.
And secondly, my lord, our representation was made before the authority, my lord, that I have submitted on 10/5/23, my lord. That is particular page 29, my lord.
Then
my lord, they have published this new NIT, my lord, 5/8/23, my lord.
who filed this?
I have filed, my lord, initially, my lord, another repetition is pending before, my lord, to dispose of our my lord, there was an interim order, my lord, to dispose of our representation, my lord. During the pendency, my lord, as there was some typographical mistake, my lord, it was my IA file, my lord.
Yes.
Lordship, first of all, no settlement order was issued.
Huh?
No settlement order was issued. It is only a proposal, Lordship. Finally, go to the, no settlement order was issued to them.
You have received the deposit?
Lordship, received, they have paid it, Lordship. I wait, finally go to the proposal of the settlement order. Lordship. Their translated version is the 17.
Yes.
I'm going proposal for the
Allotment.
Finally go to vernacular, Lordship.
Yes.
Vernacular, page number 19, Lordship.
Yes.
It is mean mohol or potton or postap potton. It is proposal and like straight go like kindly go to the last part. Lordship. A potra per dozen or victor ukta zaboti or katyapati hokai ninon sakshakari kajjale উপস্থিত হয় চুক্তিপত্ৰ কৰিবলৈ আপোনাক জনোৱা হ'ল উক্ত সময়ৰ ভিতৰত আপোনাৰ পৰা কোনো সহায় নাপালে এই প্ৰত্যান প্ৰস্তাৱ গতানুগতিকভাৱে বাতিল গণ্য কৰা হ'ব Lordship, here Lordship, they have not come to the and they are not in position, they can't say they are in position, it is our position, we have already make it, they cannot take it, Lordship, they cannot take the position because they have not
No agreement.
they have not come to the agreement and they have to deposit, Lordship. This is a delaying tactics, Lordship. They do not give a.
What is the amount it was settled at? What is the?
Lordship, here, Lordship, they have to pay 9 lakhs. First, they have to pay
9 lakh 3,000.
9 lakhs 3,000. প্রথম কিস্তি 25% আর দ্বিতীয় শতাংশ 2 লাখ সর্বমোট 5 লাখ 13,000 স্টক বেংকত ড্ৰাফ্ট যোগে জমা দিয়াৰ লগতে 3 বছৰৰ ম্যাদৰ 4 লাখ 15,000 টকাৰ বেংক গ্যাৰান্টি জমা দিব লাগিব they have not deposited the bank guarantee this is another petition is there 1 year they have Lordship has disposed that petition.
Having not done it, they have no option but to float a new tender.
No, my lord,
Cancellation?
page 25, my lord, next 30.
Yes.
উপৰোক্ত বিষয় সন্দৰ্ভত আপোনাক জনোৱা হৈছে বৰপেটা জিলাৰ বৰপেটা মহকুমাত অৱস্থিত খাৰকুঠা মিনমহল মাটিকালি on 7/11/22 এই তাৰিখৰ কাৰ্যালয় নিৰ্দেশনাৰ পৰা সঁহাৰিজনে যিহেতু আপুনি ইতিমধ্যে 22-23 বিত্তীয় বৰ্ষৰ প্ৰয়োজনীয় সুৰক্ষা আমানত ধন প্ৰথম কিস্তি ৰাজহ প্ৰয়োজনীয় গ্যাৰান্টি মুখলৈ জমা দি যোৱা 16-11-22 তাৰিখে নিগমলৈ চুক্তিবদ্ধ হৈছে সেই মৰ্মে উক্ত মিনমহলখনৰ চলিত 22-23 বিত্তীয় বৰ্ষৰ পৰা 28-29 বিত্তীয় বৰ্ষৰ 31-3-2029 তাৰিখলৈ সপ্তম বৰ্ষলৈ নিগমৰ নীতি নিৰ্দেশ অনুসৰি পৰিচালনা কৰাৰ ক্ষেত্ৰত আপোনাক দখল ছাত্ৰ সমজাই এই চূড়ান্ত পত্ৰন দিয়া হয়
What is this then?
And then, my lord, as they have not demarcated the proper area, my lord, and next also, my lord, another letter was also issued, page 27, my lord. He did not deposit, could not be able to deposit, my lord.
Lordship, this part
Why? Why you did not deposit?
6,77,250 rupees he cannot be able to deposit because of the not proper demarcation. That's why our representation, page 29, my lord.
Why are you insisting on a demarcation? Why?
Because my lord, proper area has to be given to us so that we can fishing that in that area, my lord.
What are the adjacent fisheries?
Adjacent fishery, it was my lord, to 120 hectare. Panikali 100 hectare. Water area that is specifically mentioned, but that area has not been demarcated, my lord. That's why our representation pending and we file it.
Yes, Mr.
Lordship, this actually I have just gone through this I have page number 25 is a very relevant part, Lordship. Can it be taken at 2, Lordship? I just otherwise, Lordship, we will not finalize the settlement process.
Heard learned counsel for the parties.
Because there is this part, Lordship may reflect.
The petitioner before this court. You are what? The president of a society.
Yes.
Who is the petitioner?
Petitioner.
Who is the petitioner? Is it a society?
Not society, my lord.
Individual.
Individual, my lord.
Petitioner was settled with a fishery. What is the name of the fishery? Kharsuta fishery. Pursuant to an advertisement dated 7/11/22. Stop the area of land shown in the advertisement is 120 hectares. And the minimum yearly revenue is 8,54,608. Stop. The petitioner participated and was shortlisted as the highest bidder. And thereafter, the competent authorities settled the tender with him on 16/11, 16/12, 16/11 or 12.
16/11.
16/11, 2012 by the Managing Director, Assam Fisheries Development Corporation. Required the amounts in respect of the fishery settled has been deposited. Stop. The grievance of the petitioner is that in spite of the fishery being settled with the petitioner, the proper area was not demarcated. He filed representations which remain pending. Being thus situated, he is aggrieved by a subsequent advertisement dated 5/8/2023, whereby the same fishery has been shown to be put up for settlement by way of tender by the Assam Fisheries Development Corporation. Learned counsel for the petitioner submits that this fishery would not have been advertised for settlement again during the currency of the present settlement which has been offered to the petitioner and which is presently being carried on by the petitioner. Stop. There are Mr. Sharma, learned counsel standing counsel appearing for the Assam Fishery Development Corporation, submits that he would like to obtain instructions in the matter in respect of the status of the fishery stated to have been settled with the petitioner. Stop. He prays for a short date. List again on
First week of October, Lordship.
list on 4th,
Not on 4th, either 5 or 6 or 3.
9th of October, on which date the instructions as sought for will be furnished before the court. Meanwhile, the AFDC is directed not to proceed with any settlement of the Kharsuta fishery in Borpeta as per advertisement dated 5/8/2023. This interim order will operate till the next date fixed.
Otherwise, we have already, actually, as per instruction, they have already.
It is
Financial bid is completed.
It is further provided that pendency of the writ petition will not be a bar to address the claims raised before the department.
Already pending.
There may be some mistake also.
You check up and inform the court.
Obliged.
Yes.
Okay, by way of this writ petition, the petitioner has challenged the orders in Annexure QRNS, insofar as the order in Annexure S, which is a Bakijai notice dated 4/8/2023 for recovery of an amount of 30 lakh rupees or for purported revenue dues of a mahal. Insofar as that Bakijai notice is concerned, that is totally without jurisdiction. And the other two orders, wherein notices were sent to the petitioner, are in violation of the Minor Mineral Concession Rules 2013. I'll very briefly narrate the facts, my lords. My lords, pursuant to a advertisement, the petitioner before your lordship was settled with a silk mahal, my lord. Silk mahal, namely the Dhonsiri silk mahal, my lord. The settlement order, my lords would find at Annexure A, page 26. The settlement order is dated 15/2/2017, and the mahal was settled for a period of 7 years. Although the mahal was settled for a period of 7 years, insofar as the environmental clearance was concerned, my lord, that was only issued for a period of 1 year, which was extended by the authorities, my lord. So initially, the first application, the first environmental clearance was issued on 8/2/2017, and the same expired on 7/2 the next year, my lord, after a period of 1 year. And thereafter, the second environmental clearance was also issued, and thereafter the third. Now, my lords, when the time came for issuance of the fourth environmental clearance, my lords, at the third environmental clearance, if I may kindly point out, that expired on 28/02/2020. Now, thereafter, my lords, even before time, even before expiry of the environmental clearance, the petitioner applied for the fourth renewal, my lords, of the environmental clearance. But my lords would know, my lords, the date 28/2/2020. Thereafter, my lords, the pandemic hit the world, my lords, and the entire offices and everything were shut. Therefore, my lords, the environmental clearance could not be issued to the petitioner, and therefore he could not carry out his mining operations, my lords. The third environmental clearance expired on 28/2/2020. Thereafter, there was no mining operations by the petitioner. Thereafter, again, my lords, on 13/10/2020, he again applied to the environmental clearance authorities for renewal of the mining clearance, environmental clearance, my lord, which was not renewed. Now, my lord, may kindly turn to page 65 for a moment, my lord. Very important, my lord. It's a copy, it's a letter issued by the DFO, page 65.
Yes.
With reference to the subject, this is addressed to the member secretary, State Environment Impact Assessment Authority. With reference to the subject cited above, I have the honor to submit herewith mining plan prepared by recognized qualified person so and so and approved by so and so, so and so, so and so, in the name of Sri Deepak Bora, who is the petitioner, my lord, for 7 years. Accordingly, environmental clearance was granted by letter number 1, 2, and 3. It speaks about the 3 environmental clearances, my lord. In this regard, I would like to inform you that the previous environmental EC period, as mentioned above, expired on 29/2/2020, but due to pandemic lockdown period, the office could not function properly, resulting with renewal proposal of EC in time.
Notices were issued in 22.
Yes, a lot.
Yes,
So what happened pursuant to that?
my lords, thereafter, since, my lords, the EC was not renewed, I could not function. But nonetheless, my lords, I had paid the kist amount. Thereafter, after repeated applications and verbal applications for renewal of the EC, since the EC was not renewed,
EC to be renewed by whom?
the member secretary, State Environment Impact Assessment Authority. In fact, the DFO himself writes to the member that he renew the EC, but that was not done. And therefore, my lord, I, on 15/12/2020, my lords, at page 80.
Now this recovery amount is for what purpose?
My lords,
In respect of what?
my lords, in respect of purported dues for which I did not even operate the mining, my lords, because
You
there was
did
no
not
EC.
You did not operate is a different issue,
Yes.
but it is for that period for which the mine was it was settled
They
with
have
you.
levied till the 6th year, my lords, whereas I could only operate till the 3rd year. In the meantime, I had already surrendered the mines, my lord. At page 80, for a moment, lordship would kindly see.
You surrendered.
I surrendered, my lord. There's no other option, my lord. I'll read it out. Page 80.
In 2020 itself.
2020, I surrendered, my lord.
Hmm.
Sir, respectfully, I beg to submit that I have been running Dhonsiri Silk Mahal.
No, you don't have to read the whole thing, but
My lord.
tell us that you surrendered in 2020.
15/12/2020.
Where is the agreement on the basis of which it was settled?
Agreement, my lords, Annexure A at page 26.
What is this? Is there any surrender clause there?
No, it is there in the rules, my lord. Rule
What does the rule say?
21, I'll read it out, my lord. The minor mineral concession
Minor
rules.
mineral.
I've given a book list, my lord.
Rule
Rule 21, my lord.
21.
Bengal public. 21, lordship has it.
Yes. 21.
21, surrender of mining contract. The government may accept the contractor's request for surrender of a contract or part thereof in cases where it is established that it has not been found feasible to operate the contract run for whatsoever reasons, subject to the condition that the contractor, number one, has been regular in furnishing production returns as required in terms of the contract agreement, has been taking requisite steps for the progressive mine closure plan as per conditions of the contract grant, is not in default of payment of any dues of the government.
So
as
you're
on
hit
date.
by clause 3.
Yes. Yes, ma'am. There was no due, my lords, at that point of time.
Why?
Because I had already surrendered till the time I had operated the mines,
Ah.
the kist amounts were paid. Now, when I didn't have the environmental clearance, I could not have operated. Now they cannot levy charges for that period. And in fact, they had levied charges for the entire period, my lord. 2020, I surrendered.
Yes, yes,
Thereafter,
respondent. Let us, yes.
Just one more point, my lord.
Ah.
The other two impugn orders that your lordship would adjudicate, but insofar as the Bakijai notice is concerned, that lordship may kindly come.
Bakiza is ordinarily hands off. Why
Yes.
should we?
Because my lord, it's totally. I'll.
You agitate before the
No, my lord.
officers.
I would have. There's a provision for appeal, but it is totally without jurisdiction. Just for a moment, my lord. Page 104, the Bakijai notice.
104.
104.
Yes.
It says 34,96,343. So the due has been considered to be a public demand.
Hmm.
Now, my lord would come to the contract, my lord, at page 26 for a moment. Page 26. No, my lord, the MC1 contract is at page 28. I'm so sorry, my lord. Lordship has it, my lord.
Yes.
My lord, the contract provides that if there is any due, my lord, that can be recovered as public demand. It says that as per the contract, any dues is recoverable by means of public demand under the 1913 Act. Now, my lord, you see, strangely, the contract, first of all, it is not registered, and second, it has not been signed by the DFO. Nowhere, my lord. He has just given the stamp, my lords. There's no initials, no sign whatsoever, and it is not registered. So, my lord, can you take up the BPDR for a moment, my lord? The Bengal public demand. What is a public demand, my lord?
Bengal Public Recovery.
Bengal Public Demands Recovery Act 1913.
Patrol Gulupian.
That is local act.
Look, library does it. Yes, yes, yes.
Yes. My lord.
You read.
Yes. As per the BPDR, my lord, public demand has been defined. Now, I'll take your lordship to the schedule. It says everything mentioned in schedule 1 will be a public demand. Now, my lords, I'll read schedule 1 for a moment. So sorry, but just give me a moment, my lord. Yes. Schedule 1. Now, schedule 1, my lords, serial number 9. Any money payable to an officer of the government or any local authority in respect of which the person liable to pay the same has agreed by a written instrument. First, it has to be a written instrument, comma, duly registered, that it shall be recoverable as a public demand. Now, to invoke the clause in the agreement or the contract, it has to be registered. But I have shown, my lords, that the contract is neither registered and it is not even signed by the DFO. Now, my lord, my immediate predicament, my lords, the other two demand
Why
notices.
were you paying?
My lord,
Why did you pay the amount then?
I didn't pay the amount. I have, after
Earlier?
receiving the order, I have come directly to the court, my
No,
lord.
no, earlier, prior to that.
Even he was running the mahal.
When I was running, I was paying, my lord.
So why were you
Now he
paying
cannot
if
say
the
this is not
agreement is not
registered.
signed?
No, no, my lord. What I'm trying to say, my lord, there are other modes of recovery in the 2013 rules, my lord.
Could be.
They could not have invoked the Bakijai proceeding.
On what procedure? On
Because
what
there
ground?
are judgments, my lord. Judgments of the Honorable High Court, my lord,
Ah.
whereby it has been clearly laid down.
Is there
that
a
the
provision for recovery under the rules?
provision of recovery under the rules, my lord? Yes, there is a provision of recovery under the rules. If your lordship takes up.
Yes, Mr. Gogoi, what do you say?
Lordship, first and foremost, on this Bakijai notice, I have nothing to submit. But as far as this order of 2022 is concerned, it was passed way 1 year back, your Lordship.
I'm not seeking a stay on that order, my lord.
He
That your lordship
didn't
can
come
let
before the
them
court
file
and terminate. And the second thing is that Lordship, Annexure B, page 28, is relying on this contract, your Lordship. He's saying that it was not signed by DFO, not registered. if it's not registered or signed, how can the Mahaldar was running the Mahal, your lordship? He was running the Mahal,
What is the amount?
the amount
34 lakhs.
34 lakhs.
46 lakh, ma'am.
But
Lordship would see the notice, my lord.
When is the
I
date?
surrendered notice. I'll
48.
take your lordship, my lord.
48 is already gone.
My lord, the
Fixed date.
notice,
21/8.
my lord, is referring to the Bakijai notice.
Fixed date
Mm.
21/8.
No, we took time, my lord. I have
Ah.
immediately approached the honorable court.
So when was the next date fixed?
Next date, next date is not available.
How is it not available? It has to be available.
The concerned magistrate is on leave. That's what I've been told by my learned friend.
So the matter has to be fixed on some date. Mr. Counsel, what are you submitting?
But the date has not given.
Date has to be given. How can date not be given? It has to be a date for putting it up before the concerned magistrate.
So we have also insisting
Hmm.
give us a date, but then the concerned magistrate is not available.
That will be Gulaghat, my lord. Gulaghat, my lord.
Yes, what do you say?
lordship, I'll submit that there is a lordship proposal for renewal, your lordship. If he was not able to run the Mahal, lordship, he should have approached the environmental authority, your lordship, for environmental clearance. But here is that he has not annexed a tender document, lordship, whereby stated that the is a sole responsibility of the petitioner to obtain the environmental clearance.
That I have done, my lord. Lordship would
Obtain
see.
the environmental clearance. And as far as this order is concerned, your lordship, this agreement is concerned, the petition submitting that it was not registered, not signed by DFO. But if it was done so, then how is the petitioner running the Mahal, your lordship? He's running for 2 years. In 2022,
Why are you putting the notices 18/6/22 and 27/6/22 to challenge?
My lord, initially, my
What are
lord,
your grounds for challenge?
initially, my lord, first when I surrendered in 2020, they did not heed to my applications. But thereafter, my lord, without disposing of my application for surrender, they issued the notices. Now, since in the notices, my lord, my security amount was forfeited, and they had debarred me for 5 years. At that point of time, I said I'll put it to rest, my lord. I would not contest it. But thereafter, pursuant to those notices, the Bakijai was issued, my lord. And that was the reason why I approached this court, my lord. Page
No,
10.
that is all right. You have approached this court because of Bakijai, but why are you putting these notices to challenge? What are your grounds?
Now, my lord, if I don't put these notices to challenge,
I'm asking you, what are your grounds?
yes, grounds, because, my lord, I'll come to the grounds, my lord. Lordship would see the notice for a moment. For the grounds, my lord, I was not. Lordship would see kindly page 92. What, according to them, are the pending dues? I am challenging these notices because it is in violation of the 2013 MMC rules, my lord. Page 92 for a moment, my lord.
Let him get instructions.
Instructions till that time, lordship, only with regard to the Bakijai notice, lordship would protect me.
Will protect you provided you furnish bank guarantee.
If the bank guarantee, my lord, if I had that kind of money, I surrendered in 2020. I did not. My learned friend
You
has
don't have
submitted.
money. You project yourself to be a businessman. We are not concerned with that.
My lord,
You enter into a business deal, it goes bad.
no, it goes bad. If it was for my lapses,
We
of
don't
course,
know.
Of course.
We don't know.
No, my lord, it's on record. my
We are
lord.
not here to find out who's at fault. We are
Well,
here. You have presented before us that you got into a contract. As per the contract, you are required to pay that amount. You failed to pay
I
that
totally
amount.
understand. But
Now they
lordship,
have a claim over in terms of the contract.
my lord, but it has
So you
to
give
be-
us a good reason why we need
Yes,
to
yes.
see.
If lordship gives me a minute, I'll give. the
We have
reason.
given you more than 15 minutes.
Just half 30 seconds. My lord.
Huh.
The first reason, my lord, the DFO himself, in the letter what I have read, my lord, in front of your lordship, he himself says, my lord, that the petitioner has applied the EC on time. You kindly grant EC. So, what my learned friend has submitted, that it was my duty to apply for the EC, I had done, my lords. And if the authorities does not issue me the EC, it cannot be my fault. And therefore, in 2020, I surrendered the mines. Now, my lords would come up to page.
Now on the date he surrendered, what was the amount payable? According
That
to
was
him, he
already
has
paid.
cleared all the amount.
That was already
Rule
paid.
21 says, your lordship, surrendering a mining contract, certain conditions, your lordship, for surrendering a mining.
He falls under clause 3.
He's for the clause 3. We
So
do not
on the
accept his
day he
surrender.
surrendered, there was no there was no due. to
For
be
that,
payable.
for that thing,
My lord, the challans are attached at page 76 and 77. All dues were paid.
Rule 38, your lordship. If I might take to rule 30 of MMC rules, your lordship.
Once he is surrendered, why did you proceed against him? He surrendered.
Lordship, we didn't accept the surrender, Your Lordship, because
Where is that communication?
It was never disposed of, my lord. Application for
Where
surrender.
is the
Lordship,
communication?
This is a speaking, the order at 27/6/2022.
Page number?
And page 101, Your Lordship.
Yes.
If I may read, Your Lordship, 102, Your Lordship. The third paragraph, whereas the LOI holder applied for surrender MCA by the application is so and so. In this connection, DFO Gola informed to LOI holder for fulfilling provision rule 21, chapter 4, MMCA for deposition pending dues before surrender to MCA white office notice so and so, so and so, so and so. Lordship, on 18/6/2022.
Lordship would see what that is, I'll show you. Lord. But the fact remains they could not have levied the charges for the period.
And the second,
Admittedly, I did not operate the mines, my lord.
and the second
Because of
part,
their lapses, because EC was not issued.
whereas the LOI holder neither submitted the extended EC nor deposited pending dues till date.
This order did not say that pursuant to termination, he is required to pay this amount. You have already forfeited his amount.
And barred me for 5 years.
There, the rule 38 of the MMC rules comes in, Your Lordship.
Where have you stated it?
It's in the rules, Your Lordship.
Where have you stated in the order?
It's in above circumstances under rule 38/6, Your Lordship.
38.6, what does it say?
38/6/4. Condition of mining lease, so on 36. Sub rules 6, Your Lordship. Sub rule 6, may I read, Your Lordship?
Yes.
In case of any default in payment of installment of dead rent, contract money, royalty, contribution to Mine and Minerals Development Restoration Rebellion Fund on the due dates, the amount would be payable along with interest at the following rates, Your Lordship. There's a charge, Your Lordship. If paid within a period of 7 days from due date, the grace period of up to 7 days is allowed without any interest. If paid after 7 days, but up to 30 days of due date, 15% on the amount of default or period of default, including the grace period. At number 4, Your Lordship.
But he has cleared the amount.
Please clear the amount, Your Lordship,
Then
but
where is
the
default?
interest, because since he was settlement for 7 years, Your Lordship. For 7 years,
Therefore, he surrendered it. Your
he
clause
surrendered,
says
but
on
he
the
has to
date of
pay the entire
surrender,
amount, Your Lordship.
on the date of surrender, there should not be
It
anything.
should be prorated, my lords. Till the time I operate, I'll pay.
You furnish bank guarantee, otherwise no stay.
My lords, kindly, only the Baki Jai, my lord. The rest, no.
Learned counsel for the parties. This writ petition is filed with the petitioner, putting to challenge the orders dated 27/6/2022. What is the earlier order? That's the only order?
Hello? The impugn orders are at annexure QRNS, my lord. Page 91, 96, and 104.
18/6/2022, 27/6/2022,
And the
as well as the
Baki
Bakijai notice dated 4/8/2023. The petitioner was settled with
Silt Mahal, my lord.
Silt Mahal, namely the Dhansiri Silt Mahal, for a period of
7 years, my lord.
7 years, with effect from
15/02/2017.
15/02/2017. Stop. Because of various reasons, including the COVID pandemic situation, petitioner was unable to effectively carry on the contract. Stop. One of the reasons urged by the learned counsel for the petitioner is non-issuance of the environment clearance certificate by the state, what? State
State-level environmental
level environment
impact assessment
Authority.
impact assessment authority. Stop. Under such circumstances, the petitioner surrendered his settlement. Stop. In the process, by virtue of the order dated 27/6/2022, the settlement was terminated and his security money deposited was forfeited. And he was debarred for grant of fresh mineral concession. He was barred from participation for a fresh tender for about 5 years, for 5 years, with effective from the date of issue of the said impugned order. Stop. Being thus situated, the petitioner was thereafter served with a notice dated 4/8/2023 issued by the certificate officer under the Bengal Public Demand Recovery Act, Section 7. Stop. In terms of the said notice, an amount of rupees 34,96,343 was sought to be recovered as
Nine.
a certificate in respect of the said amount has been issued. Stop. Being aggrieved, the present writ petition has been filed, praying for adequate orders, including interim orders. Para. Mr. Gogoi and Mr. Borua, learned counsels, appear for the respondents.
I appear for respondent number 1, 2, and 3, Your Lordship.
Mr. Borua for 1, 2, 3, and Mr. Gogoi for
No, I am for 5, 6, 7.
Mr. Borua for 5, 6, 7, Mr. Gogoi for 1, 2, and
1, 2,
3.
and 3, Your Lordship.
1, 2, and 3. Submits that the amount is found due and therefore certificate was issued and consequent proceedings under the Bengal Public Demand Recovery has been initiated, and therefore the notice dated 4/8/2023 for recovery has been issued. The learned counsel submits that under the Assam Minor Minerals Concession Rules 2013, the amount which is found to be due is recoverable as public demand. Therefore, the provisions of the Bengal Public Demand Recovery Act has been invoked. So there is no infirmity in the order impugned dated so and so, as well as the consequential proceedings for recovery of the amount. They submit that the since the petitioner failed to run the settlement in terms of the provisions of the rules, the amount is due and is therefore recoverable. Having heard learned counsels for the parties, this court considers at this stage to issue notice since learned's government counsels appear for the respondents, notices are waived. No private respondent.
No private.
No. Yes.
However, sufficient extra copies be furnished to the respective government councils within 1 week from today.
No, 5 also. 4 upon 4.
4, it seems you have to take notice, my lord, step on 4. Respondent. number four.
You take
No, Lordship, I am
member secretary. Who's the member secretary?
for the state level environment impact assessment authority.
Then you appear for 1.
No, I am for 5, 6, and 7.
Okay, Mr. Borua for 5, 6, 7, Mr. Gogoi for 1, 2, 3.
I'm for 1, 2, and 3, Your Lordship. This is a complete different body, Your Lordship.
1, 2, and 3.
Yes, Your Lordship.
So Mr. Borua, number 5 is also an authority.
Yes, I am appearing.
You are appearing.
Appearing.
All right.
5, 6, and 7.
All right. However, notice on respondent 4 be taken by registered post AD within 1 week from today. Matter be listed after 4 weeks.
No coercive action. I'm not praying for stay, my lord. No coercive action till then, my lord. The matter would become infractuous, my lord, if they. And I have shown, my lord, the dues which are not recoverable, they have no coercive action. Kindly, my lord.
You pay bank guarantee.
Only coercive action, not no stay. Only no coercive action till the next date, my lord.
What is the meaning of coercive action? You are not going to be arrested.
My lord, they would, my lord. It has, my lord, the penal liability as per the BPDR Act, my lord.
If you are arrested,
So kindly,
your
my lord,
remedy is Mr.
only till the next
Mr.
date, lordship, let them take instructions and lordship.
Mr.
dispose
Bia
of
is
the
already giving a big grin, having a big grin on his smile behind you in case you are arrested. List after 4 weeks.
Some protection, no, kindly, my lord.
Till the next date fixed,
Yeah.
no
Thank you.
recovery in terms of the notice dated so and so.
I'm very grateful, madam. I'm deeply obliged. Very grateful.
At least fix a date.
Here in this case, my lord, I am praying for 2 weeks time, my lord, since there is a negotiation in between the bank and the petitioner, my lord.
At the request of Mr. Alam, matter stands adjourned for 2 weeks. 10 November. 10 November. Or 10 November.
May I please? Lordship, in this matter, petitioner is the settlement holder of a min mohalla. If his settlement has been cancelled, lordship. Whatever, lordship, this min mohalla was handed over to him on 28/10, lordship. Lordship will find page 20, translator. This is the final settlement order, lordship. Page
Sorry?
20, lordship. This is the final settlement order, lordship.
Yes.
Thereafter, petitioner deposited more than 7 lakh rupees, lordship, and he was running the fishery, lordship. In the meantime, petitioner submitted a representation for deduction of 210 days as the fishery was handed over to him lately, lordship. During the pendency of that lordship representation, lordship, the authorities have passed this impugn order, lordship, letter issued and cancel this settlement, lordship. Whereas the petitioner has deposited more than the amount of current year, lordship.
Yes, Mr. Sharma.
Page 10 is the lordship.
29. Yes, but revenue was not paid, so it was cancelled. Lordship. Revenue was not paid, that is the reason. Lordship.
Page 10, lordship, make a lordship. Page
You
10.
get instructions? You get your instructions, heard? Learned counsels for the parties. This writ petition is filed by the petitioner putting to challenge the order dated so and so 11/9, whereby the Rata Min Mahal, which is a fishery under the Assam Fisheries Development Corporation in the district of Karimganj, was settled with the petitioner. By which order?
Lordship,
28/10. 28/10/2022 was cancelled for non-payment of non-deposit of the required revenue in terms of the agreement entered by and between the petitioner and the Fisheries Corporation. By the said impugn order, the earnest money deposit was also stated to have been forfeited, and recovery for due amount will be taken through Pakijai proceedings. Stop. Learned counsel for the petitioner submits that pursuant to the settlement held of the said fishery on 28/10/2022, regular deposits have been made by the petitioner in respect to the fishery. According to the petitioner, he had made
page 10, lordship. Page 10, I have
he had made more deposits. Page number
10, lordship, of the report.
he has made the following deposits. Page 10, para 8.
Bank guarantee.
And has also submitted a bank guarantee of rupees 3,31,995. Stop. According to the petitioner, there are certain adjustments required to be made as the petitioner.
It's 23, lordship.
Lordship can dispose.
Yeah.
Lordship can dispose of this matter by allowing us to dispose of this petition. Lord. Till then, we will not do.
Yes. Earlier also, lordship.
Praying for pro rata deduction of the settled revenue for the current year 2022-2023 in respect to the said fishery. The learned counsel for the petitioner submits that by way of a representation dated 31/10/2022, the matter was, the concerned authority was urged to look into the issue and pass appropriate orders. Stop. However, the said representation remained pending and no order as such was served on the petitioner. However, during the pendency of the representation, the impugned order dated 11/9/2023 was passed, whereby the Rata Min Mahal settled with the petitioner to cancel, and his security deposit, earnest money security deposit, was forfeited. Stop. Para Mr. Sharma, learned counsel appearing for the corporation, submits that he has no instructions in respect of the representation being filed. Stop. Para, this court is of the view that the matter need not be kept pending at this stage. Stop. Can be disposed of with a direction to the respondents to look into the grievances of the petitioner on the basis of the representation stated to have been filed dated 31/10/2022. Stop. The authorities will thereafter pass effective orders, speaking order, and furnish copies thereof to the petitioner. Stop. However, in the meantime, if any order has been passed, the same shall be furnished to the petitioner. Stop. The authorities will hear the matter and as directed and pass effective orders within
15 days,
within 30 days
30 days.
from the date of receipt of a copy of this order. Till the
Certificate
matter
copy
is
submitted
disposed
by-
of.
Certificate copy to be submitted by.
Yes, till the matter is disposed of by the authorities concerned. The impugned order now, if the authorities find that any relief can be granted to the petitioner, consequential orders will be passed. Till the date such orders, till the date any speaking orders are passed, the corporation will not proceed for fresh allotment of the concerned fishery pursuant to the said order.
If not given earlier, till now.
We are putting it like that. All these ifs and buts will create problems.
That's it. Okay. No issue.
We are not staying it. We are only saying that it shall not be no fresh settlement pursuant to this order till your order is disposed of.
I may be allowed, others I will suffer lordship. This is their lordship. I'll suffer.
It is already cancelled. It is already cancelled. So we are giving them liberty. If they agree with your submission, they will recall and pass appropriate.
We'll consider lordship.
Writ petition stands disposed of in terms of the above.
Obliged.
Yes. The petitioner before your lordship is a company which is dealing with fire equipments, my lord, with regard to the helmet, face, boots, gloves, and all, my lord. The impugned order that has been under challenge, my lord, is from page 15 to page 19, my lord. Page 15 happens to be, my lord, GM portal, wherein respondent number 4 has initiated, my lord, a proceeding against me. At page 15, my lord. 115, my lord. I'm sorry, 115.
115.
Yes. And my lord, at page 119 is the show cause notice been issued
119, my lord. That is the show cause notice that has been issued by the same authority, my lord, without jurisdiction, my lord. He doesn't have the power. He's not the state. Now, coming to the factual matrix of this case, may I take your lordship to page 30, my lord, will kindly come to. This has been a tender that has been floated, my lord, at page 30.
Yes.
Now, my lord will kindly see the item category, my lord. Fire proximity jacket and trousers, firefighter helmet, firefighter boot, firefighter gloves, fire anti-flash hood. Now, all these items, my lord, the total quantity, my lord, will kindly see 8085. Now, 8085, my total quantity, my lord, if it is been divided by 5, it will be 1767, total dress, my lord. Now, my lord, the past experience, kindly see, my lord, 70%, my lord, of the value, previous experience is required. This has been a tender that was floated in 2022, my lord. Now, may I take your lordship to the specification part at page 37.
Yes.
Coat and trousers, my lord, will kindly see standard EN 469 2020 or latest version. Protective clothing of firefighters performing requiring for protective clothing for firefighting. This was the standard has to be there. Standard is 2020 or latest. Now, this has been on the basis of minutes, my lord. That yes, that minute, my lord, will kindly come to page 43. It is their document, my lord. And in page 43, my lord, 1.1 will kindly see, my lord. Technical specification is regard to, my lord, 2020, my lord. 1.1, my lord, last kindly see GEM 2020, so and so has to be followed, my. Now,
Yes.
next document, my lord, in these tender documents, we participated, my lord, we become the L1, my lord, but for reasons, my lord, it is cancelled, my lord. We have no grievances with regard to this. Now, again, they have floated tender with regard to same, my lord, page 47, kindly see. Page 47, my lord.
Yes.
Now, my lord, will kindly see total quantity, my lord, 1617. That is 8085. Same quantity, my lord. Now, they have reduced past performance to 50%, my lord. Third from bottom, my lord, third column from bottom, 50%. The more important thing is like firefighting equipments, my lord, firefighters, the latest has to be there. Now, with regard to that particular standard, my lord, will kindly see page 49. Conformity of EN standard, my lord. Fire proximity suit, trousers, and so 2005 fireman helmet, so and so, 2012, so and so. It has been reduced to 2005, my lord. From 2020 and latest, it has been reduced, my lord. So getting this, my lord, after being this has been published, we file a representation at page 55. Kindly see, my lord, that representation. Page 55. To the to Assam Fire Emergency Services, Assam headquarters. Now, my lord, will kindly see first, second, third paragraph, my lord. The standard of fire suit mentioned in your tender so and so is now absolute and is now replaced by 2020. A document completed. My lord, will kindly see these are the UN standard, United Nations standard, my lord.
Yes.
My lord, will kindly see that particular document. EN standard I have given in, my lord. Last page, my lord. Annexure, my lord, 2. Protective clothing for firefighters, performance requirement for protecting clothing for fire, so and so, so and so. 5th September 2020, it has been withdrawn. And 23, they are floating tender, my lord, with regard to 2005, which was withdrawn in September 5, 2022. I pointed out to them, no exchange, my lord. They proceeded with the tender process, no issues. I being a company, my lord, and I participated in that particular tender process, my lord, wherein, my lord, will kindly come to page now 56, my lord. And this is with regard to the specification that we have, I'm sorry, my lord, page 57, my lord. Now, when the tender process was called for, certain queries were made by certain parties, my lord, at last portion. Please let us know if you need loops on the shoes. The clarification comes from the department, my lord, boots need to be with loops, stroke, alternative better method for ease in wearing shorter time, comfort and convenience in use in emergency situation. That was the answer from the department. Now, accordingly, my lord,
Yes.
I submitted my bids, my lord, 68. The model I have given in is, my lord, you'll kindly see first paragraph itself, CE certified EN 469/2020, level 2 standard, so and so, so and so, so and so. And with regard to the boots, my lord, we'll kindly see at page 69. What is my make, my lord? Herbal Art 8687 LS. Yes, so there are two specifications. LS is without loops, L is with loops, my lord. And for that purpose, my lord, I submitted my certificate also. Kindly see, my lord, page 71. That is the manufacturer is from Malaysia, my lord. Same number, my lord, 8687 L series, 8687 LS series. Both are manufactured. Certificate number, kindly see, my lord, 2777. This is the specification. 24840101, so and so, so and so is the specification. Now, my lord, at page 72, kindly see, my lord. This is the letter of confirmation I have submitted with my bid document. Letter of confirmation, so and so, we Harvik Rubber Industries, this is from Malaysia, my lord. Our so and so fighter boots offering article number 8687L, article so and so LS. Both articles are firefighting boots, are certified EN so and so 12 covered under module so and so, so and so, so and so, issued by Satara Technology Europe Limited. 8687 and so are covered under the same model series as they are manufactured from the same composition of raw materials and accessories. We have designed two separate article numbers so and so, so and so, and so and so, so and so. Now, my lord, will kindly come to, yes, 76, my lord, will kindly come to 76. A query has been raised by the department at page 76. In the tender process, my lord. The document and case certificate submitted along with technical bid for the offered fighter boots are incomplete and not as per bid document. You are requested to furnish the test report as per the bid document. As for the document submitted by you along with technical bid for fighter boot, it is found that your offered item is not with loops, stroke alternative better method as per the response published in the bid document. You are requested to clarify the same. This has been a query, my lord, and this is in the GEM, my lord, Government Electronic Market. That is in the system itself. And for this query, I get 48 hours to reply, my lord. And my lord will kindly come to now page 77, my lord. Within these 48 hours, I could not reply because technically it is because I have to bring all this information from Malaysia. I could not. But what I did, my lord, I could not upload this in the portal itself, my lord GM. So I send it after 48 hours to the email of that particular fire department. Respondent number 3, my lord. And here I have stated, my lord will kindly come to page 78. Here I said, my lord, 86L7L. So my product is LS as well as L. So you say, if you do not want if you want the loop, L is also there. That I submitted, my lord. Then thereafter, what they did, my lord, will kindly see. Page 80. Yes. Now, my technical evaluation that has been rejected, my lord. On what ground, my lord, disqualified? Bids submitted by you found to be not technically suitable as per GM bid document. And response published thereafter, hence disqualified. So within 48 hours, I could not. So it was disqualified. Okay, well and good, my lord. Page 81, my lord, will kindly see. In the GM, my lord, portal itself, I have the right to file a representation. I filed the representation and it was also rejected, my lord. That time is very important. And the reasons, bids submitted by you found to be not technically suitable as per GM bid document and non-submission of response to the clarification within the stipulated that 48 hours I could not. So it was rejected. So appeal was also rejected. Fine, my lord, nothing agreed by it, my lord. So I write at page 82, request for release of my EMD and my sample. Yes, 82, my lord, this is my letter. And 83, my lord, they release my sample as well as EMD. And when I found my sample, my lord, it was absolutely still intact. They have not seen it also. They have rejected it, my lord. And they proceeded with the tender process. After the technical bid, they opened the, my lord, at page 84, kindly see. They opened for the price bid, my lord. And the price bid at page 85, my lord, will kindly come. Deepak, Sri Deepak Export, item category, fire proximity suit. Rate has been given. Is regard to 1716. Is 7 crore 82 lakhs 62,800. So per suit, it amounts to 48,400, my lord. That is the rate been given by them. So thereafter, my lord, I wrote to the principal secretary, my lord, wherein I stated that this is the tender process is regard to, my lord, 2020 and thereafter the standard, UN standard. But it has been, they have called for the tender with regard to 2005 standard, which is absolute and been withdrawn. Secondly, I have stated, my lord, that the rate quoted by the price bid that has been quoted is 48,400 per suit, whereas they have supplied to Bihar in 30,700, and, my lord, to other state. That I take your lordship to the document itself. At page 91, kindly come to 91 once, my lord. New facts and documents has emerged that 91 or 5, you know. New facts and documents emerged, and the forthcoming loss to Assam government shall be 4.5 crore. I have pointed out, my lord, it's my right, I have availed it. At page 93, my lord, will kindly see. This is with regard to Tripura. What was the rate, my lord? 20,000, my lord. Same company, same article. My lord, second product details, my lord, will kindly see. 20,000, more than 100%. This is in Tripura. Page 98 again, my lord, will kindly see. Patna, 30,070 rupees. Page 98, 30,070. That is 70, more than 70% high. So after this, my lord, what I am on.
What was your rate?
My rate was never been opened, my lord, because technically I was disqualified, my lord. And much lower than that, my lord. Even then it is not open. 103, my lord, will kindly see. So after writing this, pointing out to the principal secretary and government of Assam, this letter comes from Home Department 103, my lord. With regard to my letters. 104 also Superintendent of Police, Vigilance Department, Government of Assam. And 105, my lord, 106 is the Lokaयुcta proceeding. I have complained to the Lokaयुcta. This is the order. Notices has been issued. And thereafter, this show cause has been issued, my lord. And in proceeding has also been initiated in the ZAM portal itself, my lord. And this is without jurisdiction, because under this particular act itself, under which it has been issued to me, it is the power of the state government, not an officer, my lord, of the chairperson of the tender committee, my lord, respondent number 4, who I have been.
Where is where is the show cause?
Show cause, my lord, you kindly see 119, my lord. My lord, the person against whom I have complained of, he's been the prosecutor, and the judge. Special DGP become Director, Fire and Emergency Services, my lord. He is the head of the tender committee, my lord. And I have made him a party by name, my lord. And the rule says so, my lord, that it is the state government who has the power with regard to debarring, my lord, not otherwise.
Yes.
Rule 46, my lord, Didier. It is the debarring from bidding, my lord. Yeah. Assam Public Procurement Act 2017. At page section 46, my lord, a bidder shall be debarred by the state government if he is convicted of an offense. And he's been issuing vindictive, nothing else, my lord. Apparent, my lord. My tender documents has not been accepted, well and good. Price document has my EMD has been returned. My sample, which I given seal pack condition, has been returned in seal pack conditions. And thereafter they went for price bid, and the price is too high. So I pointed out to the authority concerned, and with regard to the standard which has been absolved, even in spite of my representation, they did not change it.
Now, why did you not respond to the queries raised within 48 hours?
Because of the fact that it was a Saturday, my lord. My lord, and whatever information is this from the manufacturer, it will have to be certified. And it takes more than 48 hours. So what I did, my lord, 19/6, that 48 hours comes into play. On 26th, that portal I cannot load it. So I send it to the email address, my lord. I'm not on cancellation of my lord, my technical bid and all such things. I am on with regard to
This
show
is
cause.
this is only a show cause.
Absolutely, my lord. But the moment they pass an order, my lord, wherein they have no jurisdiction, it's a state government, my lord.
So you urge all these issues before their authority.
No,
It's a
my
show
lord,
cause.
here a notice has been issued by an authority who has been the prosecutor, and the judge.
Who
He
is
cannot
supposed,
be.
who has to issue the notice?
The state government, commissioner and secretary, my
Under
lord.
what provision are you referring?
17, my lord. 46, my lord.
46.
46, my lord. Absolutely.
Yes, Mr. Borwa.
Lord, this is just a show cause. We have issued the show cause.
No, you have issued, he says you have no authority to issue.
We have not yet debarred by the Lordship.
Before you
Yes,
debar,
boss.
before you proceed, you have to satisfy, you have the authority, you are the authority to issue the show cause. Get your instructions, hard
Lordship.
learned counsel for the Mr. Bhuya, appearing for the petitioner, Mr. Borwa for the respondent. This petition is filed by the petitioner putting to challenge the show cause notice dated 7/9/2023, issued by the Special DGP cum Director, Fire and Emergency Services, Assam, Guwahati. The said show cause notice was issued asking the petitioner to respond within 10 days to show cause as to why debarring, steps like debarring / blacklisting against the petitioner would not be initiated under the Assam Public Procurement Act 2017. Mr. Bhuya, learned counsel for the petitioner, submits that the show cause notice is generated on the ground that the petitioner raised certain objections in respect of the prices for the supply of the required items, which were firefighting items,
Qualities, my lord.
pursuant to the tender notice dated,
Yes.
page number.
Page number, my lord. It comes in, my lord. 4523. Page 47.
Pursuant to the tender notice dated
4523.
Where do you find it?
At the top, my lord. Right side.
47.
Yes, 4523. Yes.
4/5/2023. Stopped by the said tender. The Home and Political Department, Government of Assam, called for supply of firefighting items, including various firefighting items. Stop. The petitioner responded, participated in the tender process. However, he was not considered to be a responsive bidder during the technical bid, and ultimately it was settled with the lowest bidder. Stop.
It has not been settled, my lord. It's under process.
Lowest bidder was selected for being awarded the tender. Stop. Learned counsel for the petitioner submits that he is not aggrieved by the rejection of his tender papers. However, as a concerned citizen, he has, through his sources, found out that The lowest bidder has been settled to supply the tender at a rate of rupees 48,
Is 48,400 per suit.
48,400 per fire suit,
Yes.
which is a very exorbitant price as compared to the
Tripura,
market
Bihar.
rates available. Stop. Petitioner has referred to the rates in respect of supply of similar fire suits to various other governments like the government of Tripura, state of Tripura and state of Bihar, where the prices submitted by the same party,
Same party.
the same shortlisted tenderer, is rupees 20,000 and rupees 30,000, 30,070 respectively for the said fire suits. Learned counsel for the petitioner submits that the petitioner raised these objections before the concerned authorities, and perhaps because of his raising such queries, the impugned show cause notice has been issued seeking to debar him / blacklist him under the provisions of Assam Public Procurement Act 2017. Stop. Mr. Bhuya further submits that in terms of section 46 of the Act, debarring from bidding is to be issued only by the state government. Stop. The present show cause notice is issued by the
Director.
Special DGP come
by the special DGP come
director.
Director, Fire and Emergency Services, Assam, and he does not represent the state government. Stop. Under such circumstances, the show cause notice being without any jurisdiction, he has approached his court praying for appropriate orders. Para. Mr. Borua submits that this is a show cause notice.
Yes,
The petitioner has to respond. Thereafter, appropriate orders may be passed against him. Stop. It is premature at this stage to come to a conclusion that the department has already proceeded to blacklist the petition. Stop. Having heard learned counsel for the petitioner, this court is of the view that prima facie it appears that under the Assam Procurement, Assam Public Procurement Act 2017, it is the state government who is authorized to blacklist person, blacklist a tender. So the show cause notice is not issued by the show cause notice, a perusal of the show cause notice does not reflect. It is issued by the competent authority representing the state government. Stop. However, this view is a prima facie view, subject to such information or instructions that will be placed before the court by the respondent counsel. This court is of the view the matter will require some examination, therefore let notice be issued, returnable after 4 weeks. Since Mr. Borua appears on behalf of the respondent authorities,
I am not for all.
representing respondents 1, 2, and 3.
1, 2, 3, and 5.
1, 2, 3, 5. 1, 2, 3, and 5. Notices are waived, however, extra copies be furnished within 1 week from today. Notice on respondent 4 and 6 by registered post AD within 1 week from today. Dust is also permitted. Let the matter be listed again on 10 November. 10 November.
My lord, may I pray one thing, my lord? Same proceeding by the same officer, my lord, in 115 also, JAM, my lord. Government, electronic, my lord, market. Same proceeding, my lord. Same person has initiated, same thing. This is also required to be without jurisdiction, my lord. State, my lord.
115 is?
Please 115. Government e-marketplace that I have paid in my interim order, my lord. The state of further proceeding connection incident report IR so and so forth.
You raised some incident. You
No,
raised,
that
you,
particular respondent number 4 issued my show cause notice. He also initiated before that this my lord, JAM authorities. Same authority with regard to this at page 115. My that one same authority, my lord. Same allegation.
This is a reply, Lordship.
Proceeding. This is a proceeding.
let, um, till the next date fixed, the impugn show cause notice dated so and so shall not be given effect to. Let us see what information comes
Right.
the next day.
I'm deeply
List on 10th.
and no courtship. May I pray for no courtship by JAM? Otherwise, one is been stayed, but other will move and double jeopardy will come in. In fact,
What is GEMS?
James is one government electronic market, my lord. They
what
have the
proceedings
power.
they can take up against
Yes,
you.
same authority, my lord. Has complained and they have taken an initiative, my lord.
What is that initiative?
That initiative with regard to my lord incident report at page 115, my lord. Will kindly see
Where is the initiative?
here in the JAM portal itself. 107.
By which document?
Page 107. This is JAM 107. my lord. And the same person, my lord, who have been trying to, my lord. Issue raised by Fire and Emergency Service Assam buyer.
So you raise some issue.
No, they raised the same issues, my in the JAM
So
portal.
107 is by whom?
By the my lord, it has been initiated. It's a portal, my lord, wherein complaint has been initiated by the same authority, respondent number 4, that is issued raised by Fire and Emergency Service Assam buyer. So it's a proceeding, my lord. And the proceeding number is also there, my lord, that I have stated.
Proceeding for what? Proceeding for what?
For my lord debarring me from participating in JAM.
No, but have you received any notice for that?
No, online. Everything is online.
No, I know online, but
Ah.
give us a sample of that notice or
This is the
communication.
one. This is the only one we have taken the printout.
No,
my
this
lord.
is a response from you.
Yes. My lord will kindly see service at the grave. Status respondent to so and so. Incident report so and so. Yes, 108, my lord will kindly see Kamal Kolita buyer added a comment on 15 so and so. So these are the things that's going on. How the proceeding proceeds on the same subject matter.
Your primary grievance is against the state,
Yes,
then
and the JAM authority also been made a party because
maybe, but what is your prayer here?
prayer, my lord, interim with regard to this proceeding. Otherwise, it is, my lord, double jeopardy, my lord, on the same allegation, set of allegations. Stay the impugn order, my lord, to stay the proceeding, further proceeding in connection incident report with IR so and so carried out by JAM authority.
It is further submitted that the similar issue has been raised before the respondent number
Yes.
6.
6.
regarding debarring / blacklisting the petitioner. So, as such, the issue is issue has been given a reference number of IR 1656615.
Yeah.
Which is presently stated to be pending before the respondent number 6. In view of the notices being issued and the court being insisting of the matter, the respondent 6 will not take any coercive action against the petitioner
Deeply obliged.
without leave of this court. Yes.
May I please, Your Lordship? My lord, the fact of the case is like this, Lordship. My lord, I participated in a tender process, Lordship, regarding Pargat. The tender box was supposed to be open at 2 p.m. But the box was open prior to that in my absence, Lordship. Whenever I inquired, I found that my tender paper was found missing, Lordship. I approached the authority. Authority has done nothing till date, Lordship. On the other hand, Lordship, the tender papers which are found in the tender box, as per those papers, I was the highest bidder.
Where did you submit it? Where is the evidence you submitted it?
Lordship, that evidence, Lordship, I kept a Xerox copy, Lordship. That I have annexed with this request, Lordship.
No, but the fact that you have submitted,
Yes, Lordship.
how do you submit put it in the box?
Yes, Lordship. And for putting box, there is no receipt, nothing, Lordship. Only I have to submit in the box, Lordship.
You get your instructions.
Okay, then.
What is the stage now?
The CS has been forwarded to the ZPC for approval also.
Settlement only.
No,
You have filed any representation?
yes, Lordship, I have filed representation with the chairman of the Ansulik.
What
Panchayat.
orders have been passed there?
Nothing passed, Lordship. Till date.
So we dispose it off.
My lord, his representation is at page 29 to the commission of
Yes,
PhD.
Lordship.
That has not been disposed of.
Not with this, Lordship.
So we dispose it off.
Yes, my lord, within 2 weeks.
Third learned counsel for the parties. This writ petition is filed by the petitioner.
But Lordship, I may be allowed to file press representation.
No.
Lordship.
Who participated in a tender process for what is the tender?
Tender paper at page 14, Lordship, NIT. Bogribari Patakata Ghat. Under,
For the Bogori Bari Patakata Ghat
yes, Lordship. Under Nairalga Ansulik Panchayat.
for ferry service,
Boat service.
boat
Lordship.
service. For a boat, for operating the service as indicated in the tender. Stop. The tender amount was 14,520. And stop. The petitioner submits that he had submitted his tender papers along with all documents. And as per the tender notice, it was supposed to be opened at 2 o'clock in the presence of the bidder on 18/7.
Yes, Lordship.
2023. Stop. However, when the petitioner went to the office, the tender was to be opened at 2 o'clock on 18/7/2023 in the office of Panchayat,
Panchayat, Lordship.
Anchalik Panchayat.
Nair Alga Ancholik Panchayat office. Stop. On the appointed date when the petitioner was present before the concerned office, he found that the tender papers were already open prior to the time fixed, and in the tender, amongst the tenders, he found his tender paper missing. Stop. Having no alternative, he filed necessary representations before the executive officer, Dhubri Zila Porikot, and before the Ancholik Panchayat, you did not file.
Yes.
Where is it?
Lordship, we did not file before the Ansulik Panchayat, but we verbally approached that statement I have made. Lordship.
He also filed applications before the Commissioner, Panchayat and Rural Development, Government of Assam. Stop. It is his grievance that the representations filed have not been addressed to. Stop. Meanwhile, The other tender papers which are available have been processed, and presently a comparative statement has been prepared, and the matter is pending approval before the
ZPC, Lord.
Zilla Parishad.
Zilla Parishad. Stop. He apprehends that uh, the tenderer could be shortlisted very shortly. Stop. His grievance is that the process for opening the tender was proceeded with contrary to the specifications given in the tender notice, and that apart his tender paper which is submitted before the authorities was not found upon opening the tender box. Stop. As such, he has approached his court praying for appropriate orders. Para. Mr. Hendik, learned counsel. What is your proper name?
Pavlov, man. PAVLOV.
Mr. P. Hendik, learned counsel. Appears for the
1,
Panchayat
3 and
Rule-
5, man.
Huh?
1, 3 and 5.
1, 3 and 5. 1, 3 and 5. Mr. Esar Porwa appears for 2 and 4.
That's one word, two, Lord.
Only 2.
Five.
Stop. At this stage, notices on 4 and 6, namely the chairman Dhubri Zilla Parishad and chairman Nayaralga Ancholik Panchayat, need not be issued, as the court is of the view that the writ petition need not remain pending and can be disposed of with a direction to the Commissioner and Secretary, Government of Assam, Panchayat and Rural Development, to look into the grievances of the petitioner in terms of his representation file, which is enclosed to annexure so and so of the writ petition. Stop. The commissioner will, the respondent number 1 will thereupon cause an inquiry and pass appropriate orders to the allegations raised. Stop. If these allegations are found to be correct, then necessary consequential corrective orders be issued by the competent authority. Stop. If be issued, stop. The commissioner will pass effective orders within a period of 30 days from the date of receipt of a certified copy of this order. Till the matter is disposed of by the commissioner as directed above, the
Let the department run the art in the meantime. Because he's seeking in his prayer that he should be allowed to run the during the intervening period till it's settled.
no, then we'll have to
That intervening period matter. He also cannot
we'll
be.
say that be disposed of within 30 days from the date of receipt of a certified copy of this order. If the commissioner finds that the allegations are correct, then necessary consequential orders be passed and the matter be put up for fresh tendering, and which in the meantime the department can consider running the, what is it called, Parghat within under the by the department directly in terms of the above written petition stands disposed of.
Lordship, till then, the settlement has not been.
Because you are not a tenderer. Office, your papers not being there, whatever is a different, but you are not a tenderer.
Till the commissioner takes a decision,
Ah.
the,
If the commissioner finds that it is wrong, he'll take a decision to run it and give a fresh direction for retendering.
Obliged.
Yes.
That is your lordship. My lord, the respondent number 2 has invited a e-tender for auction of obsolete and damaged books and waste paper for the printed materials. And your lordship will find that e-tender at page 22. It starts from page 20. and the conditions are at page 22. Now, the respondent number 3 and 4, in fact, my lord, after that, the technical and financial bid was opened, and a tender summary report was published in the website. Your lordship will find it at page 70.
Yes,
Out of 8, 4 was admitted. Serial number 1, 2, 7, and 8.
yes.
Those are admitted, but upon receipt of the documents, the bid documents submitted by the respondent number 3 and 4, we could find that they have violated the bid conditions of 1.9, 1.10, 2.2, as well as 2.4. Lordship, the bid conditions at page 22, 1.9 says the bidder must have minimum annual turnover of rupees 1 crore or above for each of the last 3 financial years, 2020, 21, 21 to 22, and 2023.
Who does not satisfy that?
The respondent number 4 does not satisfy this. And the 1.10, bidders should have up-to-date income tax return for the financial year 2019 and 20, 2021 and 21-22. The respondent number 3 does not fulfill this. And the condition of clause
What about the person in serial number 1 in page 7?
Well, he complies with that. He complies with it. That's why I have not made him a party.
All right.
I'm against 7 and 8. So their bids were supposed to be rejected at the technical bid opening, at the time of technical bid opening. My lord, clause 2.2 of the general conditions, it says, in case of registered firms, the bidders have to produce one certificate from reputed waste paper recycling industry that the party is authorized to leave old.
No, now what is the stage now?
Now,
Stage is at the financial bids.
the financial bids has been opened, and on 19th, on 20th, I have given a document showing that the financial evaluation has not been done, and the award of contract has not been
Yes.
given to anyone. So on last 20th,
According to you, these 3 and 4 ought to have been rejected at the technical stage.
technical stage.
We should have left between you and the other person.
Other
That's serial
person.
number 1.
Yes.
Yes.
On 20th,
What is the bid value?
The bid value is the reserve price is 22,20,000.
Okay. So what is your instruction?
Lordship, on the last occasion, we were asked to produce the records. So records are here. Now the tender evaluation committee, the technical committee has gone through the documents submitted by these 2 parties, and we are prima facie satisfied that they have the financial capacity and they can do the work allotted to them. After that, financial bids have been opened, Your Lordship. And the 8th bidder, which is one of the private parties, has quoted 40,01,550. And the petitioner is also technically qualified. He has quoted 26,91,750. And otherwise, his case is not that some relaxation has been given to the private bidders, private parties, which has not been granted to him. If some relaxation, the law in G.J. Fernandez is clear, Lordship. If some relaxation has been granted to one party, then it has to be granted to all the parties. And the technical committee has come to a clear finding. The records are here. I'll just produce the records for Your Lordship to produce it.
Yes.
I flag marked the relevant portions, Your Lordship.
When is it likely to be issued?
The financial bids have been opened, Your Lordship. On the last occasion, verbally, this court had requested my colleague not to pass any orders. Otherwise, because waste paper has waste, it's waste paper, Your Lordship, it has to be disposed of within some short time, Your Lordship.
Yes.
I just page number 155 for once, Your Lordship, of the record.
Of the record.
Lordship.
Of the record.
Of the record.
Yes.
This is the reasoning given by the committee. I flag marked the page, Your Lordship. 155.
155.
155.
Yes.
This is the minutes of the tender committee for disposal of obsolete damaged books. One of the private respondents, the reasoning is at the bottom of the page. In respect of Messrs. RJ Enterprise, their technical bid is considered to be responsive in view of the fact that the bidder, although did not upload the ITR for the financial year 2020 and 2023 online, a hard copy of the same was available along with the hard copies in the bid document submitted by the bidder in the sealed envelope. Considering the fact that the bidder had paid the taxes for the financial year in question, which is evident from the ITR that was submitted on 31/12/2022 and which was prior to the date of submission of the bid, and it is in the IT departmental domain, and there are other evidential financial documents in the certificate from Sapphire Paper Mills regarding the receipt of waste papers from this bid for the last 3 financial years, which is above rupees 1 crore, supported by ledger and tax invoices. Considering all the supportive financial documents which indicates towards compliance of our terms and conditions in the bid document, hence the bidder is considered as responsive and thus technically qualified. And the other private respondent, Lordship will find on the next page, page 154. Otherwise, because we are only concerned with this party because he is the H1 bidder now. In respect of Messrs. Tara and Ratnamolli, although the bidder had uploaded the annual turnover certificates for the financial years 1920, 2021, and 21-22 instead of 2021, 21-22, and 22-23, in view of the turnover for these financial years being far above the required annual turnover of ₹1 crore as per the bid condition. Further, although the bidder did not upload the copies of supply order challans against the supply of obsolete books, waste papers, and other printed materials as proof of supply to paper mills, but they have submitted a certificate showing their turnover for the financial years 1920, 2021, and 21-22, issued by Messrs. Sapphire Mills Private Limited, along with supporting ledgers, which is considered as the proof of supply. Considering all these supportive financial documents which indicates towards compliance of our terms and conditions in the bid document, hence the bidder is considered as responsive and thus technically qualified. And the petitioner was also technically qualified. And after opening the financial bids, he has come as H4, Your Lordship. There are 3 bidders above him. And that Your Lordship will find at page number 163, Your Lordship. That is also flagged.
Now, what are the conditions in the letter?
My lord, as far as now, my friend is saying that the condition of 1.9 and 10 has been complied with at the time of submitting the hard copies of the bidding documents, not at the stage of filing on the online. I will press for whether this respondent number 3 has complied with condition 2.4. Because my friend has not referred to as whether this 2.4 has been complied by the respondent number 3 or not. Page 23, madam.
Two point
3. Oh,
2.4.
page 2.4, page 23.
2.4.
Oh.
No, this is about something else. You're talking about how are the bids to be submitted? All
That is
online bids.
Yes, 2.6.
Hard copies also to be submitted.
Yes, 2.6 says so. After online submission of e-tender, both technical and commercial bids, the parties have to submit hard copies of the technical bid along with all supporting documents in a sealed envelope, superscribing technical bid document e-tender number so and so.
Okay, so far as the party who did not submit the ITR, it was available in the hard copy.
It was as per
their information. Mr. Pathak
Lordship.
is available in the ITR.
It's available in the ITR.
Sorry, hard copy.
Hard copy was provided.
Now, so far as the other respondent,
Other respondent, he submitted instead of 2021, 22-23.
no, how are these to be certified? Who certifies them?
Yes, he has submitted annual turnovers must be certified by a CA.
No. Annual turnover. That's what I'm saying.
Yes.
Who certifies? CA.
CA.
But you did not mention about that. You said something about supplying books or something like that earlier.
Yes, Your Lordship, there are two conditions which the petitioner is challenging.
Uh,
One is regarding the financial documents and one is regarding the experience. If somebody is not a recycler of himself or recycler, then he should get experience from somebody else.
hmm.
At page number 155.
This is RJ is what? This ITR is about the ITR.
ITR.
Okay, then
RJ has.
then you say there are other financial documents
Yes.
regarding receipt of waste paper from the bidder for the last 3. How is this relevant?
Because the petitioner is saying that he does not have the experience. He had submitted a representation before us. So this was why it was reconsidered.
So after representation, the respondent number 3 has probably submitted
Yes.
all these
No,
things.
no. This was before it. After representation, this orders were passed.
These are not available in the website.
Which one?
All these documents which my learned friend is now.
Then what is the point in having an e-tender?
No, Lordship. The object of e-tender is that it is for easy submission. Now, if the tender process allows submission of hard
Why
copies.
are you complicating things? Whatever mode you want physical tender, you ask for physical
No.
tender. You are asking for an e-tender. You are allowing them to supply hard copies. There are some mismatches in between.
And if the law is clear, if there is a difference between the hard copy and the soft copy, the hard copy has to be considered, Your Lordship.
Provided the soft copy is there.
No,
He
here we
says
are.
the soft copies are not even available. What is the where is the tender? This is the one included in the petition. That is it.
My lord, I'm also happy on this. Probably this they have skipped this clause 2.4.
Hmm.
The respondent number 3 does not fulfill this condition also.
You get your instructions properly, Mr. Pathak.
Your Lordship may kindly see clause 2.6 once.
Hmm.
It allows for submission of both online
No,
copies and hard
correct.
copies.
We do, but
Yes.
what you are the author of this NIT,
Yes,
no
sir.
dispute. You know
Yes,
what
sir.
is good, no
Yes, sir.
dispute. But kindly tell us what is the rationale of having two sources of supplying and thereby leading to this confusion.
No, otherwise this is the usual procedure which is followed, Your Lordship. Why this is so, Your Lordship? Because this happens often that
We are not asking you why. We are saying that if you want to do away with e-tendering, do away. But you are allowing you to e-tendering. Some
Yes, sir.
documents are uploaded. Some are supplied physically.
no, 2.6 it says
Uh,
after online submission of the e-tender, the parties have to submit hard copies. So
correct. Of the
e-tender,
documents which are submitted on the
which are
through the
submitted on the e-tender
e-tender.
process. So, Your Lordship, if I today,
If one of the tenderer fails to submit or upload in the e-tendering, which is to be done earlier,
yes, Your Lordship.
how do you justify selecting that tender? Merely because it is supported in the e-document.
By the hard copy.
What I'm saying is, on a day when you submit
Yes, Your Lordship.
through e-tender,
Lordship.
that document may not have been available.
Yes,
Is
Your
a
Lordship.
possibility.
It's a possibility.
You are allowing that possibility to come into a reality by adopting this process.
Lordship.
If it was e-tendering, you should have
Lordship.
stuck to e-tendering. How do the court now find out that on a day when you submit the tender,
Yes.
what is the date for submitting?
First June of
The date of submission is
1st June.
So now at what time were these documents uploaded and when were the physical documents handed over?
what we can do, Your Lordship, is if we produce the bids, the complete bids of all the parties, that will make it clear the
Mere
hard copy.
production will not help. You
Not
find out and you tell us. We don't need to go through your records. Why should we?
Because otherwise that is their case, Your Lordship, that
We don't take pleasure to go through your record. We have sufficient records to go through.
I understand. Your
So
Lordship.
you point out and tell us that yes, on this date,
Lordship,
the document was submitted.
Lordship.
And on the same day, this document was available. There has to be a nexus between the
But
two.
otherwise, yes, I understand what your Lordship is saying, but otherwise
Otherwise, what happens is whatever documents I have, I put it on upload. The rest I will get it by physical mode and supply it. And you take a decision that it is already available in the physical mode.
yes. But if we have taken that decision, your Lord, for argument's sake, your Lordship, for argument's sake, we have taken a decision that we will accept the hard copy as well. For argument's sake, that's something, a document which is not available in the online mode, we have accepted the hard copy, physical document which is submitted
But
before the
that is
last.
not a specification in the tender.
That
That
may
is not clear.
may not be, but 2.6 allows submission of both online and hard copy.
It does,
Now,
but that will not lead to an interpretation that any documents not found in the website, you will rely on the hard copy.
What I am trying to say, your Lordship, is that unless the case of the petitioner is that he could have also submitted some document in to physical mode, and he was not allowed to do so, and because the relaxation was not granted to him, he is prejudiced.
You have to satisfy
Lordship.
that. You see, kindly read your 2.6.
2.6.
Read it again.
2.6. 2.6 says after online submission.
No, wait. It begins with the word after.
After online submission.
So you first have to make an online submission.
First make on online submission.
So after online submission, you have to submit hard copies of what?
Of the technical bid.
Of what? Of the documents which were submitted online.
Hard copies of the technical bid, yes.
Submitted online.
Yes, with all supporting documents.
So you now have to tell us from your records why the document was not submitted online. He has to give a reply.
The respondent perhaps has to give a reply. Now, what I am saying, it's from the reverse, your Lordship. Is now suppose if the petitioner had made out a case saying that relaxation which was granted to the private respondent was not granted to him, and that is why he is prejudiced, then it was a very good case for him, your Lordship. His case is that relaxation should not have been granted to him.
That is how you want the case to be presented. But here is a case where he has submitted on a, you have given a timeline.
Yes, your Lordship.
Submit online.
Yes.
After you submit, give hard copies.
Yes.
Now you tell us that on a time when he submitted, uploaded, it is admitted that document was not there.
Yes, it was submitted before opening of the bids. Yes.
You said this ITR certificate was not there, but
Yes.
it is there in the hard copy.
Yes, it is there in the hard copy.
So at the time when he submitted.
So all I have to, perhaps what is following from your Lordship is that since 2.6 allows hard copies to be submitted before opening of the technical bids, if he has submitted it before opening of the technical bids, then perhaps he satisfies the requirement.
You 2.6 says after you submit online.
Yes, it says after I submit online. Then I have to submit the hard copies before opening of the technical bids.
Right.
So if he meets that timeline, perhaps
not only the timeline, you have to perhaps you have to make an inquiry to find out why it was not there. It is not a very simple clause to say that okay, you don't have it in the online, you have it in the hard copy, we'll have it. The idea is it will amount to a relaxation without even he pointing it out.
Yes, it will amount to a relaxation.
It will amount to a
relaxation.
That you have given him, he may not have had that ITR document or other document.
It will amount to a relaxation. But then relaxation per se is not. I'll not produce. I'll just.
Then you have to ask him. You have to satisfy that it is not. It is not arbitrary.
Yes, I'll just ask. I'll get the instruction why it was not in the online bid. Otherwise,
it's open to you to pick anybody up and say, okay, we give you the tender. Why go in for this process?
Yeah, I understand your Lordship. But the law of relaxation is that unless it is not evenly applied to every party.
This is not an express relaxation. This is an inbuilt relaxation.
It is.
You gave him a relaxation without finding out whether on the date it was uploaded, he had the document. It could be that he wanted to upload it, sent it, it did not get uploaded because of XYZ technical
Very
reasons.
well. Lordship may have it on Wednesday, Monday, your Lordship, I'll get the instruction.
Just for the addition, 1.16 clause says that all eligible in 1.15, page 22. All eligible interested bidders are required to download tender documents from the ASTPCC Limited's website Assam textbook in or Assam government e-procurement portal, which is to be uploaded along with all supporting documents in the e-procurement portal after filling up. So it has to be through e-procurement.
And hard copy as well. So, and hard copy as well, the lordship. Because 2.6.
So it makes no sense to have a hard copy because if you are going for e-procurement or e-tendering, what is the idea of having a hard copy? And who's going to compare?
Because generally, your lordship, what happens is that the records are still maintained in physical form.
You
So hard
download
copies
it.
are insisted upon.
You download it from the website, take a print.
But this is usually the procedure which is being followed. That is perhaps the only justification for having hard copies, because records are maintained in physical form. And if there is any discrepancy,
No, there is only one justification. Department doesn't want to spend money on the printouts. You want to settle it on the tenderers. You give us a hard copy, we'll preserve it. That's it. That's the only thing. But this has led to this kind of confusion.
lordship, I'll get that instruction on Monday. Lord. That whether if he had that document when he had uploaded the bill, and if
Department does not realize the difficulty, the tight spot they will get into it by maintaining this clause.
lordship,
We are not advising you.
Lordship.
But you see, these documents are voluminous.
lordship,
Now there cannot be a discrepancy between soft copy and the hard copy.
they can.
Who's
should
going
not
to be, who's going to verify all that?
lordship,
For that, you'll call another tender.
lordship,
So this is not a very innocuous clause.
lordship.
It gives a handle, if required, to room for some arbitrariness.
If it does, it does.
Heard learned counsels for the parties in terms. Was there a direction to produce a record earlier?
Yes, your lord. My
Order
colleague has volunteered to.
There was no direction. Anyway, the learned departmental counsel, Mr. K.P. Pathak, has produced the records which reveal that the objections raised by the petitioner are found to be not tenable by the department, and the financial bids have been opened, and there are 4 shortlisted bidders, and the petitioner is at the is the last shortlisted bidder in the financial criteria. Stop.
H4.
During the course of the hearing, in respect of certain clauses, interpretation of certain clauses and the compliance of these clauses by the respective bidders, more particularly clause 1.9, 1.10, 1.16. Any other clause?
2.6.
2.2, 2.4.
2.2 and 2.4.
And 2.6 as well. Lord.
And 2.6. The learned departmental counsel submits that he would like to complete his instructions and appear presented before the court on the next date fixed. Accordingly, matter be listed again on Wednesday.
Monday, it's
Monday, it may not come. Tuesday or Wednesday.
very well. Wednesday, then we got
Be on 27th. 27th.
Till then, my lord.
let the matter come up in the motion column. Your
Yes, be listed for motions. The departmental counsel will produce the relevant records if required. And till then, the bids may not, bids if finalized, shall not be proceeded with.
Very
Applies till the next date
well.
fixed.
Obligation.
Sufficient extra copies be furnished to the respective government council by the counsel for the petitioner within the course of the day. Record to right over.
In this case, before this starts, Your Lordship, in this case, I had filed an written objection yesterday. However, that is not on record. So
Why are you objecting? Who are you?
I'm the writ petitioner, Your Lordship.
Oh,
They
you're
are-
objecting.
They have filed an impleadment petition. I had filed an
Impleadment for
objection.
impleadment for whom?
For respondent number 5, DC Sonitpur as respondent number 5.
5. So what is the objection
Oh.
there?
Oh, sorry, I'm sorry, Your Lordship. I'm extremely sorry.
Heard? Anyone for the respondents? Water resources? Any objection?
No.
Heard learned counsel for the parties. This IA has been filed by the petitioner seeking impleadment of the opposite party number 5, namely Deputy Commissioner Sonitpur Tejpur, to be arrayed as respondent number 5 in WPC number 4363 of 2023. Learned counsel, MS so-and-so appears for the respondent, Water Resources Department, who does not object to the prayers made. Accordingly, the IA stands allowed. Deputy Commissioner Sonitpur Tejpur is directed to be arrayed as party respondent number 5 in WPC number so-and-so. Stop. The registry will make necessary endorsements and the petitioner, after the petitioner files amended post title in the registry within 1 week from today. Stop. IA stands disposed of. In the writ petition, you write, in view of the order passed in IA, respondent number 5, DC Sonitpur, DC Sonitpur, Tejpur is arrayed as respondent number 5, subject to the petitioner filing amended course title within 1 week from today. Matter will be listed after 2 weeks.
I apologize, Your Lordship.
Yeah.
Before my learned senior.
Somebody made a mention here.
Yes, Your Lordship, I made a mention in the morning. I have filed an objection, Your Lordship. There is not on record. So may I pray it may be fixed on Monday or Tuesday, Your Lordship?
I have to file a reply against that objection. Let it be fixed up other days, Monday.
All right, Mr. Ferry, learned counsel appearing for the petitioner,
Petitioner.
submits that he has filed an objection to the IA filed by the applicants who seek to be interveners.
Yes.
Stop. However, the said objection stated to have been filed by the petitioner opposite party is not on record. Matter be listed after 1 week. After 1 week. The
Let it be after 2 weeks. In the meantime, I can file my
right
objection.
after 2 weeks, and the opposite party writ petitioner is also permitted to file complete the instructions in respect of the IA stated affidavit objection, which is stated to be filed by the writ petition.
I am appearing for respondent number 1, 2, and 3.
In the writ petition, MS so-and-so appears for respondents number 1, 2, and 3. 1, 2, and 3. Okay. List after 2 weeks.
May I pray for a fixed date, Your Lordship?
Fixed date. Then it will be 2 months. Take your chance in 2 weeks if you can.
Deeply obliged.
May it please your lordship. Lordship, this IA is for my lord, impleadment of the central goods and service tax represented by the Commissioner Guwahati and Principal Commissioner Central Goods and Service Tax in WPC number 4749, my lord, of 2023. In this case, my lord, the petitioner exclusively deals with the business of wheat, my lord, which do not require any GST registration under the provisions of the Central GST Act and the circulars made thereunder, my lord. So pursuant to the order dated, my lord, 23/8/2023, my lord, there is a verbal instruction, my lord, by the honorable court that we need to implead the parties, my lord, in the writ petition. So my humble prayer before your lordship, kindly pass an order. For
GST.
Yes, my lord, GST, Central GST.
Yes, what do you say?
Copy have not been received.
My lord,
IA copy have not been received.
IA you've not served. Copy of the IA. You are
I'm
appearing for
appearing on behalf of BK Singh for FCI.
FCI. You have
Yes.
not served copies.
serve it, my lord.
Serve it. Serve to all the respondents. Or we can issue notice if you want.
Yes, lordship.
For respondent number 5.
Huh?
I'm for respondent number 5. Union of India.
Why don't you serve copies instead? What is the point in keeping an application pending? You serve copies, we'll take it up on the next day instead of issuing notice.
Lordship, we will serve it within a day.
Learned counsel for the petitioner will serve extra copies. We'll serve copies of this IA on the government counsel, Mr. S.S. Roy, CGC.
Yes, CG,
You are appearing for whom?
respondent number 5.
Respondent number 5, the Union of India.
That's
And MS so-and-so appearing on behalf of Mr. B.K. Singh, counsel for the FCI.
Yes.
The,
Respondent number.
the matter be listed after 1 week,
If you are-
by which time the copies be served as directed. Yes, government.
In this case, my lord, I have just received information. Instruction is ready. Director is out of station. That time, my lord, it would take some 3 days, 3 or 4 days, my lord. Let it come after.
I have
4 days.
serious objection to this type of prayer, my lord, at this hour.
Why, my lord? Why? I have received.
Because the lordship will see,
My letter has been responded by them, and they have
they
PPI.
are so negligent. How many times has been granted?
When is the director coming?
Director will, my lord, 3-4 days.
3-4
No,
days.
3 or 4 days.
3 or 4 days, my lord.
Is it third day or the fourth day?
Third day, not
Third day.
third day.
So third day will be Wednesday,
Wednesday,
which is 27th.
27.
So we direct the director to be present in court on 29th along with the records to assist.
Not standard.
No. You let him come. Let us hear from him what he has to say.
On 29.
29th. Mr. Mondo?
Lord, I leave it to your lordship. Otherwise, I am ready to place my argument. Lordship may take care of the case as and when lordship hears them. Kindly see, my lord, time without number.
Your grievance is that you are a person with disability. Your case was never considered. There were no.
Mine, not only mine. None was considered.
None
This is
was
an
considered.
admission case.
It is in reference to that we are asking for the instructions as to whether any person was at all
Appointed
selected.
or not, my lord.
My lord, their categorical stand is
Hmm.
nobody was
No,
nobody was appointed.
the petitioner
They are
was not
affidavit.
qualified.
They are affidavit.
They are-
Therefore, my lord, what I beg to submit is without going deep into all these controversies, the lordship will find that there was admittedly no selection, no appointment made in the quota of physically disabled person.
All right.
Then it is a gross violation of the provisions of the law. And I am the only candidate now before your lordship.
No, but then if the benefit is offered, it can't be restricted to you alone.
Well, there has to be a selection.
Exactly.
They didn't make it. They
So
didn't make
what
it.
is your prayer today?
My prayer is that my lord, so far the records are concerned, lordship directed on several occasions to them. They have not been able to produce anything. So
Right.
it appears that there is no record to show that there was a selection or any appointment, and which has been admitted by them at page 86, lordship will find.
No, that's all right. But what is your direction? What is the direction you want from?
Direction is that, my lord, my responsible submission.
In
is
order to
me.
set aside a written examination held in 2016
Yeah.
and the Viva Voce,
Yeah.
you'll have to array all the parties.
My lord,
No.
not necessarily. Not necessarily, my lord.
Then,
Because I am in the quota of physically handicapped.
hmm.
Admittedly, there was no one elected or appointed.
Is there any process likely to be conducted?
Yes, conducted.
When?
The selection was conducted. She was not qualified. She is getting only 17 marks.
Oh, that is their case.
Well, now,
Others
is
are
why-
getting more than 40, 45 like
kindly
that.
see at page 56, 86. They are categorically state. Thereafter, what remains? All these are bust.
86.
Yes. 86 of the Malad petition.
Yes. Affidavit.
Affidavit. It starts at page 85. 85. It starts at page 85. This is the third affidavit filed by them. That is the Director of Social Welfare. Page 86, third line, Lordship, except in the year 2015, no candidates were selected in the category of physically handicapped.
Hmm.
So this was in 2014.
Hmm.
2014 advertisement was floated. That time I applied and there was a selection made. Now they said that in 2015 there was another advertisement. Some people were selected that time. So they said that except in 2015 there was no selection. The categorical admission is that there was no selection, no appointment in the category of PWD against the advertisement of 2014. 20 posts were advertised.
No, they say no candidates were selected.
Select. Except in 2000, no
They do not
candidates
say
were
that no selection was made. They said no candidates were selected.
selected in the category of physically handicapped.
That's right. So it does not mean that candidates did not apply or were not considered.
Yes, that is what they said, not considered, but then not selected in that category. In that case, Lordship will find, was there any benchmark for the selection on merit? Was there anything else? Nothing. Otherwise, there could have been selection of any ABCD in that category,
This is why the records are necessary.
but they have not been able to produce it.
We have stated in our affidavit, my lord, he only pays only 2 lines. Thereafter, but in the 2019, Government in Social Welfare Department initiated a special recruitment drive to fill up backlog vacancies.
No, that is in
2020.
2019. We are concerned with 2014.
What debarred the petitioner? What debarred the petitioner to participate in the 2019?
That's a different issue, Mr. Sutia. We want to know in 2014 what happened.
2014,
Were there any applications? Were they considered? If considered, was anybody appointed? That's all we want.
I will produce it.
And you have been giving assurances and assurances since last 2016.
That is
Nothing has come.
For that, my lord, I am sorry, my lord, because I am, my lord, bound by, my lord, what is behavior stated.
No, you don't have to be sorry.
Without any instruction, my lord.
We are therefore sorry that we have to call for the director to assist us.
Last time,
So,
which director?
Last time,
let the director, no, let director be here with all records, and that is the final.
no, this is only to assist. It's not don't take it in the sense of a personal appearance.
Exactly.
We want the director because this matter is a fairly old matter.
If there is at all some records,
Yes.
let him come and explain.
Yes, I will inform you.
Right? Heard learned counsel for the parties, Mr. T. Chutia, learned additional senior government advocate, submits that he has received instructions, verbal instructions. However, he submits that matter be deferred for another 3 days as the director, women and child. What is it?
My director is absent in the
Director of which department?
social welfare.
Social welfare.
Women and child development.
That is what
Women empowered and
is social welfare available
social
today or?
bifurcated 2, my lord.
So he's a director of which department now?
Women and child development.
A director, Women and Child Department, Government of Assam, is out of station. Considering the fact that number of opportunities were granted to the government to produce the relevant records / instructions as to whether any selection at all was made in respect of persons with disability during the selection process conducted by the department in the year 2014.
14 of advertisement dated 24 to 2014.
Relating to the advertisement dated
24/02/2014.
24/02/2014 issued by the Department of Social Welfare as it then was, and whether any persons with disability like the petitioner was selected and appointed. So
Considered it.
the affidavit
At page 86. I pointed, this is the third affidavit.
The affidavit dated 10th of August 2021, filed by the director, reveals that file in the affidavit filed by the director, filed on so and so by the director, there is a categorical averment that except in the year 2015, no candidates were selected in the category of physically handicapped. Stop. However, it is, however, Mr. Chutia, on the other hand, submits that the selection was made, the petitioner had appeared, but she could not secure the required benchmark and therefore was not selected. Under such circumstances, we direct the Director Social Welfare to be present in court on 29th, along with all necessary relevant instructions in respect of the instructions sought for in respect of the said selection process which was conducted in the year 2014. Matter be listed at the top of the list on 29th.
Deeply obliged.
Instruction, they may understood something else. Lordship may also say record.
Let him come along with records.
Yeah.
Director along with records, relevant records.
Obliged.
Copy of this order be marked to the office of Mr. Chutia during the course of the day to enable the same to be communicated to the Director of Women and Child, Government of Assam, for due compliance of this order.
Deeply obliged.
Please, Your Lordship. The matter may be taken at 2 p.m.
Why?
At 2 p.m.
Why?
My senior is lagging. Your Lordship, we have not yet received any instructions on this issue.
What is the issue?
Otherwise, the matter relates to dismissal from service. Now, the matter was dismissed for default in the year 2017. Then it was restored in the year 2020. Then
You have filed your counter.
No, Your Lordship, they have.
You filed your counter within 2 weeks. We are giving you a final opportunity, failing which we'll pass consequential orders.
Yes, Your Lordship.
Heard learned counsel for the parties, Mr. G. Bora, learned government advocate, submits that this is the matter. The learned counsel for the parties, this matter pertains to a challenge made by the petitioner questioning his order of dismissal from service. Petitioner was appointed as a constable in the unarmed branch. And he was dismissed from service on 24/12/2015 by orders passed by the Deputy General of Police, Inspector General, Deputy General of Police Eastern Range. Stop. It is seen that the department has not filed a counter affidavit. Mr. G. Bora, learned counsel for the department, submits that the matter was earlier the matter was dismissed for default and therefore there was some delay subsequent to its restoration. The affidavit was not filed. He, however, prays for 2 weeks further time to file the necessary affidavit. Stop. It is directed that the affidavit matter be listed after 3 weeks, enabling the respondent department to complete their instructions and file necessary affidavit. In the event the affidavits are not filed, the matter will be taken up on the basis of the pleadings available on record. List after 3 weeks. After 3 weeks.
Any obliged.
My lord, may finally take up the matter after some time, my lord.
What after some time? There is no after some time today. What is it? What is the matter about?
Non-payment, my lord. Contractual bills, non-payment, my lord.
Non-payment of bills.
Yes, your lordship.
What the matter has come after 2019, Lordship. I need some updated present status, Lordship.
What present status? You,
Because, Lordship, I have filed one affidavit by the respondent number 2, Lordship. In paragraph number 9, Lordship.
we
have
dispose it off with a direction.
Yes, your lordship can do
Huh?
that. Yes,
Because,
your
Lordship, in the paragraph number, Lordship,
lordship. On
9,
the last order,
some verification was
You verify and pay. You make all verifications necessary and pay in terms of Tomsar Ali.
Lordship.
Yes?
yes,
Lordship.
Okay, heard. Learned counsel disposed. Give you the order. Huh? Non-payment of bills. Yes, disposed.
yes, your lordship.
Verification to be conducted within 120 days from the date of verification to be conducted and amounts to be released if payable within 120 days from the date of receipt of a certified copy of this order. Okay?
If he is not entitled some amount, then
If found entitled.
if found entitled.
Your lordship.
Yes, please, your lordship. My lord, my mother was working as helper.
Yes.
Helper, my lord, who was died on 17/6.
Yes, Mr. Munir. Mr. Munir was supposed to be here.
Yes, my lord, I will inform him, my lord.
Where is Mr. Munir?
I will just make a call, my lord.
So who's the standing council of Hadi and village?
Mr. Munir. Whether he-
Call him at 2 o'clock. At 2 o'clock. At 2 o'clock. Please ask him to be present in court, Mr. Dhor, at 2 o'clock.
his name is not there in the call list. That
We
will-
don't know, it is reflected as some standing council's name is there.
Yes. But not in the call list. I will inform.
The instruction was short form. Your lordship, we have received the instructions on last occasion, lordship directed us to get the status of the DP number 3 of 2003. And we wrote to them, and on 19th we received the parawise comments only. But they did not state as to the status of the DP number 3 of 2003. Otherwise, DP 4 of 2004 has been disposed of, and we have stated that in our affidavit. But since that particular issue of DP number 3 of 2003.
Mr. G. Bora, learned counsel, appearing government counsel, submits that in terms of the order, dated 29/8/2023, instructions as sought for in respect of the pendency of, in respect of the status of the DP number 3 of 2003 has not been received as yet. Although the parawise comments and other instructions have been received. Stop. He therefore craves leave for further 2 weeks' time to obtain the required instructions. Mr. S. Borthakur, learned counsel for the petitioner, does not object to the prayer made. Placed after 2 weeks.
Based on the same parawise comments, we have already filed a affidavit. They have.
Well, it was.
We have given you
initiated
time.
They have sent it
It
again.
was initiated on the basis of some criminal case only. Criminal case has already been disposed of.
No, therefore we wanted to know the
Yes,
DP.
that's it, that's it.
Yes.
In this case, I am appearing for the elementary division department. We have received record today itself, my lord. And in.
What is the issue? What is the matter here?
Matter regarding provincialization, my lord, NCLT. And kindly peruse the order dated 18/5, my lord. Your lordship directed to produce some record.
You were to file affidavit. Did you file any affidavit?
No, my lord, record was called for, my lord. And today morning I received the record.
No, on 7/9,
My lord.
2 weeks further time was granted to file affidavit.
Last,
You file your affidavit, none appears for the petitioner. Mr. B. Talukdar appears for the elementary education who submits that affidavit has not been filed. He prays for further 2 weeks' time. Mr. G. Sarma appears for NC Hills. And accordingly, matter be listed after 3 weeks, enabling the respondents to file their necessary counter affidavits, if so advised.
Apply.
Yes.
May I please, your lordship?
Ah,
In so far as item number 22 is concerned, my lord, we have to file affidavit, my lord.
what are these matters?
Lordship, regarding cancellation of mining lease, Lordship.
So why is it here?
The Lordship is has to go before bench 4 or 5, Lordship, not before.
No. Why? This is Arunachal.
Arunachal, Lordship.
Why is it here?
It was filed here, Lordship.
So it says District Kamrup.
Yes. Otherwise, cause of action, everything is there. Lease deed was executed in Arunachal. Even the lease deed
Normally
says
go
that.
there.
Indian Bureau of Mines at Guwahati, my lord. The interim order was passed.
Yeah, you are appearing for whom? You are for the petitioner.
Oh, lordship, petitioner on behalf of
So pleadings are complete.
Lordship,
In one of the case, we have filed affidavit that we can rely. Lordship, I fix after puja petition, it can be disposed of. Huh? Yes.
Lordship, we have received some further instruction. Lordship, we will be filing additional affidavit.
Heard learned counsels for the parties, Mr. A. Chandran, learned senior government, additional senior government advocate for the state of Arunachal Pradesh, submits that he would like to complete instructions in the matter and, if required, file an additional affidavit. Mr. Chakraborty appearing for respondent
1, 3. For Union of India. And
for Union of India submits that their pleadings are complete.
in one of the case, we have filed affidavit.
In which case?
Item 23, Lordship.
Number?
1104. 1104.
1104, Lordship.
In WPC 1104
04
of 2022. And he submits that the affidavit filed.
Other case, we'll,
In
in
the-
the meantime, if. Lordship,
You want to file or you don't want to file?
Lordship, well, I have already sent for
He
getting. Lordship.
submits that the affidavits in the other matters will also be filed and steps are being taken in that respect. Stop. MSP Bora, Learned Counsel, appears for the petitioner. List after 4 weeks.
The earlier interim order may be containing all the cases. my lord.
Interim order passed in the writ petitions will continue until the next date fixed. List on 15th November.
Obliged.
Lordship may allow us some time to file my affidavit, Lordship.
My lord, with due respect, here in this case, my lord, along with this 27, 28 and 29, my lord, same with regard to non-payment of contractual bill. My
What is
lord,
the point? You verify and pay?
my
Lordship,
lord,
actually, this is FMP related matters.
What
And
related?
FMP, Lordship, flood management program, Lordship. And in this matter, Lordship, 80% share is from central government and 20% is from Assam government, Lordship. And we have paid part payment which is received from the state government, Lordship. But central fund, we have yet to receive, Lordship.
What is this?
my lord, what happened is that a bulk of cases with regard to similar petitioners came before lordship, but unluckily these three were left out though file at that time.
Those
In
matters
that-
are disposed of.
Disposed of with that common order,
Then-
at the last, my lord, the last 3 pages. Last year. And the last pages, my lord, I have not the relevant. Yes, sir. Those persons
In
are-
terms of these directions,
Yes, my lord.
But
Yes.
till and unless we have not received share from central government, we can't release the.
Therefore, that is what the direction says. Within 15 days, you'll communicate the supplementary budget
Yes.
and huh? Are you sure?
Yes, sir.
Heard learned council exposed in terms of this order.
27, 28, and 29 same.
27, 28, 29, same orders.
Disposed of.
Disposed of.
Highly obliged.
27 to 29.
28, 29.
Okay.
Obliged, my lord.
My lord, the matter relates to the appointment of the arbitrator. A copy has been served upon the respondent. Affidavit is to be filed.
Arbitration.
Yes, what do you say?
In this case, my lord, we have not filed affidavit. We need instruction to file affidavit for 2 weeks. Your lordship may grant time.
Why don't you appoint an arbitrator?
We have to. There is some.
That heard learned counsel for the your name, please.
M. Pandit.
N. Pandit appears for the petitioner. MS B. Dotto, learned senior counsel, assisted by Mr. A. Dotto, appears for the respondents. It is submitted on behalf of the respondents that instructions in respect of the prayers made, contentions raised in this petition, arbitration petition, are not yet complete and they require further time.
That's why.
With 2 weeks,
3 weeks.
3 weeks. Accordingly, matter be listed after 3 weeks.
Okay.
Please, your lordship matter may be taken up at 2.
No, next week.
Kindly take up to 2.
No, why?
RC na legs in other.
No, he's in legs. Okay, we'll take it up. It'll come on Monday. It'll come on Monday.
Kindly fix it to lordship.
Yes, who's appearing for the respondent? What do you say?
Respondent 1.
All right, at 2.
In this matter, my lord, we have filed our reply on last Monday. So it is not a part of the record.
Mr. Deka, learned counsel for the RM.
We have an agency, madam.
Huh?
We have an agency. They are enjoying an interim order, madam.
He says some reply is filed, not there.
Next week, my lord.
Not yet, madam.
And my lord, extension is going on till 31st of December, my lord.
Only a small issue, madam. We could not get the vendor is for.
Let the reply be part of the record. Mr. RM Deka, learned counsel for the petitioner, submits that the reply filed in response to the petitioner has been filed, but the same is not a part of the record. He submits that the reply be placed before the court, connected to the case record. Mr. S. Potakur, learned counsel for the petitioner, submits that there is an interim order as the petitioner there is an urgency in the matter as the petitioner is enjoying an interim order. Accordingly, let the matter be listed again.
Wednesday, madam.
Wednesday.
Yes, madam.
27th.
Yes.
And the registry is directed to trace out and connect the
This is regarding
reply affidavit stated to have been filed by the petitioner.
The date of retirement of my deceased mother, my lord.
Who is for the Khadi board, Mr. Borwa?
PK Muni is on legs at court number 4, my lord.
So what can I do? His matter has been adjourned at his request.
Let him serve a copy, my lord. We don't have a copy, my lord.
Copies have been served.
Copy already served, my lord. If necessary, I will serve another copy, my lord.
Copies must have been served.
Hello?
You serve copies?
Yes, I have already served.
Give him one extra copy. You can serve one more extra copy. Mr. So-and-so appears for the respondent, Khati board, on behalf of Mr. P.K. Munir. He submits that a copy of the writ petition is not available and is therefore requested for service of the copy. Stop Mr. So-and-so learned counsel for the petitioner. Fairly submits that copy of the writ petition will be served upon him. Can you do it today or next week?
I
Today?
Today.
Has submitted that he will ensure service of copy on the respondent counsel by during the course of the day. Accordingly, matter will be listed after 1 week. You get your instructions and represent your department on the next date fixed,
Much of it.
list after 2 weeks.
May it please your lordship.
Yes.
There was an NIT issued by the Jala Development Block in the BTC area for settlement of various ferry guards markets. So I being one of the prospective bidder for one particular market, that is Simla market, I bidded for it. And I was the second highest bidder. Your lordship may kindly peruse the comparative statement 56.
56.
Yes, page number 56, your lordship.
Yes.
Your lordship, the number one is Dishanath Basmotari. He is the highest bidder. And the petitioner is serial number 2, Karuna Deuri. Now, admittedly, in the column of GST clearance, it's shown that yes, why? He has submitted. But after the bids were submitted, we came to learn that the GST certificate which the private respondent has submitted, that is the highest bidder, was fake. And that is at page 63, your lordship.
How did you come to know it is fake?
We came to learn thereafter, we checked in the portal, your lordship, with his GST TIN number. So that shows to be it has already lapsed.
That does not mean it is fake.
But he has submitted his GST clearance certificate. In the portal, it has shown to be.
Where are the tender conditions?
Page 32, your lordship. This is the bid document, your lordship. Clause 8. The tenderer shall attach the tender with the following documents: bank draft. Number B, original land patta and Jamamandi copy. Number C, land revenue clearance certificate. Number D, ST/SC certificate. Number E, land valuation certificate. Number F, GST clearance certificate. So that was a mandatory requirement. Now page 33, your lordship. Clause number 14. No settlement will be made to any defaulter person or officials within the district. So admittedly, your lordship, this GST certificate which is submitted, and in the comparative statement, they have stated it to be yes, he has submitted it. But that expired long back, your lordship. And if he has submitted a fraud, then fraud vitiates everything, your lordship. Page 63, if I may draw your lordship's kind attention once again. The effective date of registration was 12/6/2020. Constitution of the business proprietorship. Cancel suo moto on 19/2/2021. So on the day when notice of motion was issued, your lordship.
GST clearance, if required.
Yes, your lordship. That is required, your lordship. He has to pay a GST. And that was the requirement. If it was not required, why he submitted the fake GST certificate?
No. Why do you keep on saying fake? It's not fake.
That he had
expired.
Expired.
It's not fake.
Expired, but that he had submitted to be a
You
genuine.
may say that this is not valid.
Yes, your lordship.
But why are you using the word fake?
The reason Your lordship is right. I should not have used that word. But the issue is that if it has expired, it cannot have been taken into account, your lordship.
If it is expired, it is expired. It is not
Yes.
fake. First, you make up your mind
Yes,
whether
your
it is
lordship.
fake or expired.
Ah.
Fake is something which is not genuine.
But that does not exist anymore. So what?
No, that does not exist, but it existed at some point in time.
But at the time of final,
It existed. It is
Yes.
fake is something which was never there.
what I want to say is that at the time of submitting the bid documents,
Hmm.
this GST.
That does not make it fake, subject to correction. It may
I'll
not
correct-
be, it may be an invalid certificate.
Yes, I'll correct myself. It's invalid. Admittedly, on that day, it was not valid, your lordship.
It was not valid. Yes.
So on the date when the notice of motion was issued, that is on 21/7/2023, this honorable court directed the Finance and Taxation Department to take instruction to that effect that whether the GST certificate was valid or not. If I may
Yes.
draw-
Yes.
Lordship, I have given instruction. The GST registration was cancelled on 19/2/2021,
Hmm.
Lordship, due to non-submission of returns.
Then, is it a necessary condition in terms of the contract
19.2.
conditions?
Here, Lordship, here I am appearing on behalf of Finance and Taxation Department for BTC.
Who's for BTC?
I'm appearing, your lordship.
Yes, what do you say?
Communication letter has sent your lordship to the concerned department, your lordship. Instruction awaited, your lordship.
What in see, they have already stated that it is not valid. The question is whether this is necessary or not.
Necessary or not, your lordship,
Hmm.
that I have to acquire. your
But if
lordship.
you have submitted, you have understood it to be necessary. If the private party had submitted.
In the comparative statement also, there is a column specifically. And
That we
clause
allow
8
to
F
obtain
states,
instruction, your lordship, from the.
your lordship, the
department,
notice of motion was issued on 21/7. That was the specific instruction they were taught to take, your lordship.
Heard learned counsel to the parties.
Your lordship, today was the date fixed for
That,
fixing of the interim orders, your lordship. So I'm
What is
pressing,
the stage of the contract?
your lordship, he is running the market, the private respondent.
Then-
And he has, no, your lordship will see one thing. There was a direction. Let me submit. There was a direction to take dusty steps. Dusty service was taken upon him. He refused it. Thereafter, the Lavazima court has passed an order that he has refused to accept it. Secondly, I have filed an affidavit to that extent and he has received the copy, but he chose not to appear, your lordship. Your lordship may kindly peruse the Lavazima court order dated 29/8/2023.
When was the work order issued?
Work order was
Statement.
issued on 7/7/2023 with effect from 1/7. The lordship will see it's the settlement order is at page 58.
So once he's running it, unless without hearing him,
The lordship, he chose not to appear. There is
that's a different issue. Department will have to be heard properly. What interim orders you want today?
that may be stayed, your lordship.
Then what happens?
I'll operate in that case
How?
because I'm the second highest bidder, your lordship.
No, there has to be an order that in the event he is found unsuitable, you will be given automatically. There has to be an order. If that order of settlement is in case of one not found to be available or incapable of running, it goes to two. There's no such order. Department will have to take a call.
Your lordship, this honorable court has passed that order. If I may just draw your lordship attention.
It's for interim orders, we'll reject it. Court says question of interim upon returnable. If you want, we'll reject you. Or if you want, we can keep it open with whatever you submit.
That can be kept open, but admittedly, your lordship,
Prima facie, I don't think any interim order is called for. Now, settlement is there. It should be made subject to outcome of the writ petition. And if possible, an early date for hearing. That's all. Or if you want, we can close it. Department will take a call. Pass appropriate orders on this. If it is not found, because you are not filing any affidavit.
No, Lordship, I have placed the instruction that will suffice.
your lordship, that being a mandatory requirement, can he give a go by to that?
I know. But the department will have to respond to this. This settlement is made by the BTC, not by GST.
Your Lordship, the department in the NIT which has been issued by them, they have stated it, that one has to submit the GST clearance certificate. And in the comparative statement, they have stated,
Alternate counsel for the parties, this writ petition is filed by the petitioner, praying for cancellation of the settlement order bearing number so and so dated 7/7/2023, page number 30. Issued in favor of the private respondent number 7 for settlement of
Simla market.
Simla Bazaar for the year 23-24. Stop. The petitioner was a petitioner applied for the submitted his papers for the for participating in the tender. However, the petitioner was not selected and the private respondent was petitioner was placed at as the second highest bidder, and the private respondent was considered to be the highest bidder, and the market was settled with him. It is it is submitted by the learned counsel for the petitioner that subsequently, upon inquiries made, the petitioner found that the GST certificate submitted, GST clearance certificate submitted by the petitioner is invalid, as the GST registration of the, GST certificate of the private respondent, as the GST registration is found to be cancelled with effect from
19/2/21.
Cancelled on the date when the settlement order was issued. It is submitted that GST clearance certificate is one of the criteria prescribed in the
Clause 8F.
in the NIT at clause, where is the NIT?
Page 32, Your Lordship.
Clause 8F. Stop being thus situated, the petitioner is aggrieved and has approached his court challenging the award of settlement in favor of the private respondent, and submits that since he did not fulfill the criteria prescribed, the settlement made in his favor is bad in law and therefore needs to be interfered with. And the petitioner, being the second highest bidder, the settlement be directed to be awarded to him. MSP Das, learned counsel appearing for BTC, submits that instructions are awaited. Meanwhile, Mr. B. Chaudhary, learned standing counsel, GST.
Respondent number 6 here.
I'm appearing for respondent.
Your Lordship, in this case, I'm alleging a malafide against the BTC authority who have settled the market with them, in spite of the fact that the GST clearance certificate was invalid.
Appearing for Finance and Taxation Department, has, as directed by the court earlier, has placed on record an order dated 9/2/2021, which shows that the GST registration in respect of the private respondent stood cancel. On 9/2/2021 with effect from 19/2/2021. Stop. Where Mr. Sinha, learned counsel for the petitioner, submits that being the position, the BTC authorities could not have proceeded to settle the tender with the private respondent by holding that he meets the requirements, he satisfies the requirements under the NIT dated so and so, including furnishing of GST clearance certificate. Stop. It is submitted that since the GST registration stood cancelled with effect from 19 to 2021, on the date of issuance of the tender, his GST was not renewed. And on the date when the settlement order was made in favor of the private respondent, which is 7/7/2023, his GST registration was not renewed. Stop. Under the circumstances, prima facie, this court is satisfied that the conditions prescribed in the NIT dated so and so in respect of clause 8 and within bracket F were not fulfilled by the private respondent, and in that view of the matter, the settlement order could not have been granted, ought not to have been granted to the private respondent without referring to the cancellation, without referring to the absence of the GST clearance certificate, without any reference to the absence of the GST clearance certificate. Stop. It is also submitted by the learned counsel for the petitioner that upon being permitted, dusty service was effected on the private respondent, who, however, refused to accept the copy of the petition, and an affidavit to that effect has also been filed by the petitioner.
On 18/7/2023.
87, 888
18/7, your lordship, I have filed, sorry.
affidavit for
Yes.
steps. Affidavit for steps.
8/8/2023.
88 filed on 8/8. He further submits that on 28/8, the Lozima court had passed an order taking on record the fact that the respondent 7 refused to accept the dusty service sought to be effected on him. Stop. It was further recorded in the said order that although AD card or unserved notice was not received in respect of respondent 7, but the postal journal and the track consignment report shows that the item stood delivered. Stop.
This honorable court has also accepted the same on 11/9/2023.
Findings of the Lozima court is accepted by the court as is reflected in the last order dated 21/07/2023. Now tell us.
Your lordship, short date may be given, your lordship.
To allow a market to be run illegally. You'll write one line. Under such circumstances, Mr. Sinha submits that the PTC authorities had proceeded to award the tender settlement in favor of respondent number 7, and such order could not have been passed unless there was a deliberate attempt by the PTC authority to do so, and which results, which is on the face of it malicious action on the part of the PTC authorities towards the petitioner. When can you get your instructions?
Your lordship, Monday, by Monday.
Monday. Wednesday. We'll give you 2 more days. Wednesday.
Wednesday.
Matter be listed on Wednesday. On which date? The learned counsel for the BTC will furnish necessary instructions in respect of the steps they desire to take in view of the order of settlement granted in favor of the respondent number 7, in view of the instructions dated 26th of July 2023 placed before the court by the learned standing counsel for the Department of Taxes, Government of Assam, that the GST registration of the private respondent number 7 stood cancelled with effect from 19/2/2021. Stop. Matter be therefore listed again on 27/9 for further orders. At a line for in view of the orders passed by the Lozima Court, the service on respondent number 7 is deemed to be complete.
Your
However,
Lordship,
none appears for the respondent 7
Your
in
Lordship, this,
spite of service being complete.
this
Yes,
court has already observed the same thing on 11/9/2023 that deemed to be served. Your Lordship, the order was issued on 7/7/2023, but they've shown to be with effect from 1/7/2020.
whatever. We'll decide. The question of interim orders, if any, is left open to be decided by the court on the next date fixed.
Deeply obliged, Your Lordship.
Your Lordship, for respondent 1, P. Biswas.
Respondent 1, what were you doing when the order was being passed? You did not make any submissions. Your name, please.
P. Biswas.
T. Biswas.
P. Biswas.
P. Biswas, learned counsel, appears for respondent number 1.
On behalf of MSN Board.
All right, we're recording your name. All right.
Wait, please, Your Lordship. In this case, my lord, today fixed for disposal of the repetition, my
Some
lord.
I is filed.
Lord, I have filed the
I
For?
filed for impleading, my lord.
Impleadment of?
Lord, the petitioner has challenged a tender quoted by the Inland Water Transport Department, my lord. There's a stay operating, my lord. I had also participated in the tender process.
You're a private party.
You're a private respondent, as a private respondent. My lord.
Okay.
Certain rights have also accrued to me, my lord, for that very reason.
Huh?
Rights have accrued to me in so much.
You are not arrayed as a party.
I'm not a rate.
Oh, then he's a necessary party.
Not a necessary party.
Why?
Please may kindly see page 46
46.
in my repetition.
Tender not issued as yet.
No, tender was it a third time tender, retender, my lord. All our INDA successful with my lord. Well, please page 46, my lord.
Yes.
Para number 7, my lord.
Yes.
As per the comparative statement, it is found that 4 bidders have participated in the retendering process for settlement of Sandarpur Kirakara ferry service for the remaining period of the financial year 2022 and 24. All the bidders have deposited their required amounts of earnest money along with tender. Out of 4 bidders, 1 bidder, Jamat Ali, has withdrawn his tender. The tender committee decided to forfeit his earnest money deposited for Sandarpur Kirakara ferry service, the estimated value of rupees so and so. The name of the bidder document submitted, number 1, Wahab, Abdul Wahab, the petitioner, my lord. All documents submitted as per NIT. Gyasuddin failed to submit experience certificate as per NIT. Jamat Ali withdrawn his tender. Sorot Hazarika, now my lord, failed to submit the proper land valuation certificate and proper financial soundness certificate. Also, the name of a technically qualified bidder and his offered amount mentioned below, name Abdul Wahab, 6,50,500. Decision. Tender committee recommended name of the Abdul Wahab for settlement of the ferry service at an amount of rupees so and so. Pursuant to this, my lord, I am waiting for my lord settlement of the Mahal in question, my lord. Now minutes of the meeting and cancel this, my lord, and given the fresh tender was issued, my lord. So I am challenged before the honorable court. The third time I am successful bidder, my lord. His bid was cancelled, not open. His bid was not open even. And this was cancelled, again cancelled, third time cancelled.
Well, then how are you an affected party?
My lords, as things stand today, my lords, rightly, wrongly, my lords, my bid was cancelled for the earlier tender. Subsequently, thereto, my lords, a third tender has been issued, which is the subject matter of challenge before my honorable, on this honorable court. My lords, for that tender, I have submitted my bid, my lord. That is an admitted position. Well, depending on the outcome of these proceedings, my lords, I am a necessary party to
Nowhere
that
he
extent.
mentioned that he is going
No,
to
for
participate.
My
Chandrapur,
lords, I have mentioned in my-
which ferry service?
for the Chandrapur Kirakara.
What is your name?
Saurabh Hazarika, my lord.
Sorod Hazarika. It said you failed to submit proper land
My lord,
valuation.
that is for the earlier tender, my lords, which was cancelled and a re-tender notice was issued,
Okay.
which
That
is the
was stayed
subject.
by this.
Now,
Which is
where is the retender is state?
Stayed by.
State.
Stayed by.
Ah.
State, my lord, I'm not
Not
disputing.
Everything
open
is-
till the returnable, not stayed by this honorable court. Only the interim order was directed by this honorable court that till the returnable date, the tender should not be open.
Hmm.
This is the position, ma'am. And we have filed our affidavit also, madam.
Now, in the fresh tender, obviously you did not participate.
I'm not.
He has
Ah.
I have participated.
Now, why was it cancelled?
Lordship may kindly have. a-
Earlier,
The early order, my lord, your lordship, the early order, my lord. There is the order, everything is there, my lord. Please may kindly speak.
Lordship,
order,
my
ma'am.
affidavit also, I have.
No, your order, my lord, page 21/8/2023, my lord. Everything is there. my lord.
Hmm.
The respondent number 5 had published in tender notice dated so and so 28/6/22, whereby seal tender were invited
So
for
that
visit.
we know, there is no confusion there. We want to know why the government cancelled it.
Lordship may kindly have a look, my affidavit for a moment, madam.
You tell us.
Lordship.
Tell
Because
us.
Lordship, in the second tendering process, Lordship, the party who is now into the,
Question is, why did you go for the second tendering when you had a shortlisted candidate?
Lordship, because the land valuation certificate which has been submitted by the Sard Hazarika, we erroneously, the department has cancelled his tender. This is the one reason we are going for the next tendering process. The another reason is that the bid value, my lord. In the first tender, bid value was higher. In the second tender, this comes down, Lordship. For generate maximum revenue,
Come to
government is.
page 46.
Other repetition, my lord. Yes, Lordship.
There are 4 bidders.
Lordship. This is the second tender, Lordship. This is regarding second tender.
But this is also cancelled.
This is cancelled and third tender notice has been
So the
issued.
question is, why did you cancel it when you had a shortlisted bidder?
Because Lordship, the 10 value of the bid value comes down, Lordship, to generate
What is the
maximum
bid value?
revenue.
What is the bid
It will
value?
become 6,50,000, Lordship.
What is the bid value?
Bid value, it was, Lordship,
4,73,000.
4.73. To generate maximum revenue, Lordship, the department. has
Oh,
issued the
he's
third
quoted
tender.
more than the bid value. You have shortlisted him.
Lordship, it is the shortlisted to every participant. The other has failed to.
They
submit the
failed.
documents.
That is why the tender.
Lordship,
That is why the tender.
Lordship. But government want to generate maximum revenue, and for the last time, it is reflected in the minutes, my lord. For the last time, the department, the directorate wants to tender the concerned ferry guard.
The question is why?
Lordship, to generate maximum revenue.
How do you know more revenue will come?
In fact, Lordship, the other party, the Sard Hazarika was cancelled, that his bid was cancelled with the erroneous ground, Lordship, because he has submitted the land documents issued by the circle officer and we have rejected his tender. But as for the queries which was sought from the deputy commissioner, it was submitted that circle officer was empowered to issue the land valuation certificate. So this is the another reason we have erroneously
But
rejected.
then you have to revive this tender, earlier tender.
Then Lordship may grant us liberty to revisit the earlier tender, second tender.
Why, what liberty? You are the author, you decide.
Because this
If
matter
you
is
want to
pending.
float-
Yes, Lordship, we want to decide, but this matter is pending before this honorable court, my lord. In fact, this honorable court has stayed the tender proceeding to not to open the tender till the returnable date. That's why we are not revisiting it. If Lordship may grant us liberty, we will go for revisiting the second tender. We will consider his land valuation certificate, which is submitted by the other bidder also. This is Sard Hazarika. He is now filed IF for impediment in this respect.
How do you know he submitted higher bid?
We don't know, Lordship, but we have erroneously rejected his tender. We have admitted. Who is the inquiry,
That is not challenged it.
Lordship, but the second we have.
You are entitled to pass an order correcting recalling your earlier order of rejection.
Then Lordship may grant us liberty. This matter is pending before this honorable court, so we are not doing
I am
at this
objecting
case.
that.
Lordship may grant us liberty, we will revisit the tender proceeding, we will stop the fresh tender, we will revisit the second tender. He also
I'm
consider-
objecting that. But
Why he has
I'm
objection?
objecting that.
It's a
Why?
tender
Because
proceeding,
of
my lord.
that, first, I am given the 9 lakhs. I am the only bidder. They did not allow me. Second, I am given the second remaining period. They given the bid bill 4,73,700. I have given them 6,50,000. But please may kindly see page 46. Saurav Hazarika failed to submit proper land valuation certificate and proper financial soundness certificate. But they mention what, my lord, please may kindly see page 50. They mention their father, page 50, my lord. Father, the tender of one bidder, Sri Saurav Hazarika, was cancelled as he had submitted land valuation certificate issued only land valuation. But they did not mention that proper financial soundness certificate, my lord.
So it is
And
up.
as per condition,
If
my
he
lord,
doesn't satisfy proper financial, he'll be rejected.
yes, my lord, as per condition, my lord, there must be a deputy commissioner, my lord. Now, once he has, my lord, that was cancelled. And again, I was earlier, I am the highest bidder, 9 lakhs. They did not. They says now it is a for benefit of money, but they did not given the settlement for whereas I am given the 9 lakhs.
This decision
my
was
lord,
also not
I'm-
challenged by the petitioner.
My lord. So yes, I am participated again, but I am offered in highest bidder. I am the only. They says earlier they says that he is the only person. So they did not. We did not give that. But same issue was only tender. They are given the settlement. Why they are discriminating to me, my lord? That wasn't reflected in earlier.
So they want to revisit this.
Yes, my lord.
They want to revisit. They want to
Lordship.
go and find out.
Well, I will file an objection regarding that affidavit filed by my learned friend. I will not file.
What affidavit?
They file an affidavit. We are going to file.
Whose file?
I have filed already, my lord.
Your file.
I am submitting for my affidavit.
I am going to file reply.
Why we have issued the third tender notice, my lords?
So who is running the ferry now?
The government.
Government running. That is why, my lord, they are not.
So
given
unless you allow the writ petition
Yes,
to
my
be
lord.
disposed of, how will private parties run?
Yes, lordship.
Oh, my lord, I am only the highest and valid bidder. So I have to give my lord, given the sons, my lord.
No, you were a valid bidder earlier.
No, now, my lord.
In the present one.
Yes.
Third tender process, my lord.
Where is the what is
Yes.
the
No.
statement of the third?
Third tender was honorable court to interpret this, my lord. I am not participated.
Not
I
to
am not
open the
participating.
tender till the
First-
returnable date.
First, I am the highest
That's
valid.
what I'm saying. Now you were the highest in the tender process, second, which got cancelled,
Yes, my lord.
and they have now attempting to proceed.
First, I am the highest valid.
First,
Alright,
the
first-
Cancel.
First
Again, they said, given the tender, I am also participate. I am the highest bidder. That again, they given the cancel, and thereby I am coming before the honorable court for the seeking justice,
So what we want to convey to you
my lord.
is that they are agreeable to revisit this order
lord.
of cancellation of the second tender
Yes, my lord.
and find out, according to them, this rejection of Saurav Hazarika was on wrong grounds. That is
Wrong.
their claim.
But,
If
now they says, but as per condition, there must be by the deputy commissioner,
no, whatever it is,
my lord.
whatever it is.
So, my lord, my prayer is that, my lord, some hearing is required, my lord. I will reply regarding that issue. If honorable court consider his implement, I am no objection, but he has not a necessary party.
Have you filed an affidavit stating all this?
Lordship.
What have
My
you
lord.
stated?
Yes.
In my lordship, may kindly have a look my affidavit. Paragraph 5 onwards, relevant, my lord. 54, running page. May I read, my lord?
No, regarding the wrong cancellation.
Yes. This is paragraph 6, my lord.
So where are the documents?
Lordship, that the deponent begs to submit that the tender of the bidder Sri Saurav Hazarika was cancelled as he had submitted.
So where is that clarification?
Clarification shot from the deputy
So
commissioner.
where is it?
I will produce, lordship, that documents
Oh.
I was given. But at the annex.
My lord, after submitting all tender paper or close the all, how they go to the deputy commissioner, my lord, if they did not submit same ground, other so many tender are cancelled, my lord. So many, there is a, my lord, deputy commissioner did not the expense certificate.
Let them get it, yes.
But they did not.
Yes.
In the IA, my lord,
that I filed, my lords, I civil 2908, my lords. At page 22, my lords, there is a clarification issued by the circle officer stating that he is authorized to issue a land valuation certificate.
Yeah, let the government bring it. Let the government say so.
Well, very well, my lord.
Lordship, I will produce that document, Lordship, the instruction that.
But as on now, as on date, you are a participant.
I'm a participant in the third tender, my
So
lord.
you can't say that he has no interest.
My lords, of course.
He's a tenderer. He wants to get the tender. He has to be implemented.
Maybe participate, but my lord, implemented, I have no objection.
Heard learned in the IA 29008. Heard learned counsel to the petitioner. This IA has been filed by the petitioner so and so, who seeks impleadment in WPC number 4760 of 2023. Impleadment as a party respondent. Stop.
Number 7.
Petition 4760/2023 was filed by the opposite party, writ petitioner, challenging the process of challenging the tender notice 2806. What is the tender? 2806.
2023.
Huh?
5th August 2023.
5/8/2023.
Page 51 and
51.
extra 8 of the writ petition, last page.
5/8/2023 for settlement of ferry service as per the schedule detailed in the tender notice. Stop. Insofar as the writ petitioner is concerned, he is interested in settlement of the Chandrapur Kirokara ferry service. Stop. According to the writ petitioner, this is the third time that the department has proceeded for issuance of tender for settlement of ferry service in respect of the said ferry ghat. So the learned counsel for the petitioner submits that in the first tender, he was the highest bidder, which came to be subsequently cancelled. In the second tender, he was the only valid bidder, offering a valid bid of 6,50,500 in response to the bid value of 473,700 issued by the department. Stop. According to the petitioner, one of the tenderers, according to the petitioner, the department ought not to have proceeded for the retendering of the said ferry ghat when there was a valid tenderer and who is the writ petitioner. Stop. Without giving any reasons, the department proceeded to go for a fresh tender. Stop. The petitioner, however, submits that this action of the department to go for repeated retendering, without any justifiable reasons, reflects the bona fide intention of the department to issue orders of settlement in favor of some blue-eyed person. Stop. Under such circumstances, the writ petition was filed. This court, while issuing notice by order dated
21st
of August 2023, directed the respondent authorities not to open the bids received in response of the retender notice dated 5/8/2023 till the returnable date. Stop. Para Departmental Counsel MS MD Bora submits that an affidavit has been filed and there is urgency in the matter and therefore the matter needs to be heard. However, it is her submission and which is also not disputed by the learned counsel to the petitioner, that the petitioner is not a tenderer in the 5/8/2023 impugned tender notice. Stop. During the course of the hearing, the learned departmental counsel submitted that the retender was necessary because the department had rejected the case of one of the tenderers, namely Sorat Hazarika, on the ground of failure to submit proper land valuation certificate and other proper financial soundness certificate. Stop. Subsequently, the department came to realize that this order, that the certificate submitted by the said bidder, Sorat Hazarika, may have been wrongly rejected. However, in view of orders passed by this court, the department is not proceeding to reevaluate the earlier order of cancellation. Stop. It is submitted by the Learned Government Council that if liberty is granted, the department will proceed to reevaluate the grounds on which the bid of the said bidder, namely Sorat Hazarika, stood rejected. Stop. Para. Mr.
B. Chaudhary, madam.
B. Chaudhary, Learned Counsel, submits that an IA has been filed, being IA number so and so, whereby he represents one of the bidders who participated in the bid which is impugned in the present writ petition, namely retender notice dated 5/8/2023. And the interim order passed by this court has affected his rights, and therefore he submits that the IA, being IA number so and so, be permitted, be allowed, and the petitioner be arrayed as a private respondent number 7. Stop. Upon hearing the learned counsels for the parties, upon perusal of the affidavit filed with the department, it is seen that there is an averment made that the certificate issued by circle officer,
My lord.
the land valuation certificate issued by the circle officer, which was submitted by the said bidder Sorat Hazarika, Sri Sorat Hazarika, in the earlier round of bidding, in which the present petitioner has been shortlisted as a valid bidder, was rejected, but subsequent clarification sought from the Deputy Commissioner Dorong. The department was informed that circle officers are empowered to issue land valuation certificate on behalf of the Deputy Commissioner. And therefore, the earlier cancellation order requires to be revisited. Stop.
But they did not mention my lord financial soundness.
Mr. Bora, Learned Counsel for the petitioner, however, submits that besides the land valuation certificate, which was not accepted, there is another ground on which the bid of the said tenderer, Sorat Hazarika, was rejected, which is failure to submit proper financial soundness certificate. Stop. He submits that once an order has been passed, then he submits that since the department has filed an affidavit, he would like to complete his instructions and if so advised, file a rejoinder affidavit. Stop. Under such circumstances, matter stands adjourned or
Lordship may kindly give a short.
how much time? 1 week.
1 week.
Be listed after 2 weeks. Enabling Mr. Bora to file the rejoinder affidavit if so advised.
I'm deeply obliged.
And you are objecting to the impleadment.
Well, not that, no problem, madam. Implementing as a responsible.
Then you add it in view of the order passed today in so-and-so, IA number so-and-so. The so-and-so is added as respondent number 7 in the writ petition. The respondent is directed to file amended post title in the registry and registry to make necessary endorsements upon such filing of amended post title.
I'm deeply
In
obliged.
the IA number 2908, right, in this application is filed by the applicant so-and-so who seeks to array himself as a respondent in the present writ petition in which the retender notice dated 5/8/2023 has been assailed. Stop. The retender is in respect of several ferry services out of which the petitioner and the present applicant are interested to participate
Chandrapur,
in
Kirakar.
Chandrapur, Kirakara
Correct.
ferry service. Stop. It is submitted that although the petitioner did not participate in the retender notice dated 5/8/2023, the applicant is one of the interested bidders and he has submitted his documents and he is hopeful that his bid will be considered by the department and the ferry settlement order may be passed in his favor. Stop. However, by virtue of the interim order dated so-and-so, the matter has not proceeded further. As such, he seeks impleadment as a party respondent in the said writ petition. Stop. Vera. Mr. Bora
Well,
does not object.
fairly submitted. No.
Yes or no?
Well, I am some objection is there, my lord. I am also, but so well, I am fairly submitted. No objection.
We still did not understand. Yes or no?
My lord, I'm no objection.
No objection. Does not have any objection to the prayer made. As also MSMD Bora Learned Government Council. In that view of the matter, without issuing notice, since respondent councils are in agreement, the IA is allowed. The applicant is directed to be arrayed as private respondent number 7 in WPC number so-and-so. The amended post title be filed before the registry by the respondent, newly added respondent, within
2 days.
1 week from today. And registry to make necessary endorsements in the writ petition pursuant to filing of the amended post title. Writ petition, I accordingly stands allowed and disposed of.
But main case, well, I'm my interim order maybe continue till today.
Writ petition interim order to continue until the next date fixed.
My lord.
My lord.
Deeply obliged.
Lordship may kindly fix in that matter. 11th of October. Obliged, Lord.
11, my lord.
Yes,
This matter may be taken up Monday. My senior counsel.
at the request of Mr. So-and-so, matter stands passed over for the day. MS N Bora appears for the respondent. PNRD department.
1, 2, and 3.
PNRD. Yes.
I need some further time. The instruction is awaited.
Mr. S.R. Borua, learned counsel appearing for the respondent, prays for and is granted further 2 weeks' time. to obtain instructions. Mr. S. Borman appears for the petitioner.
There is an interim order.
There is an interim order. Interim order passed on 3008/2023 shall be extended till the next date fixed.
May please your lordship, this matter may take with the WBC number 5211.
It is further submitted that by the learned counsel for the petitioner that this writ
WBC
petition be connected along with WPC
5211/2023.
5211 of 2023. Accordingly, let both the matters be listed together after 2 weeks. Give a date.
Highly obliged.
11th October.
Here pleases your lordship.
Yes.
Your lordship, R. Mazumdar is appearing on behalf of respondent number 5. He is not well, your lordship, having fever, your lordship.
Last week, last couple of days, it was mentioned he has gone out of station.
Yes, your lordship, he is not well, your lordship.
He's not well. Yes. What is the issue about?
Next week, any hearing the lordship,
Hearing day.
hearing the lordship.
All right, hearing day. It is submitted that Mr. R. Mazumdar, who appears on behalf of Department of School Education, is indisposed. MSP Das, Learned Counsel, makes a mention on his behalf and prays for an adjournment. Mr. D. Bhuya, Learned Counsel, appears for the petitioner. Matter be listed after 3 weeks.
Deeply obliged.
2017 matter, lordship.
18.
17 order, lordship, 2018 matter, lordship.
Then
Short date maybe given, lordship.
short date.
Short date. Next week, lordship. Any
Next
day.
week. 6th October.
6 October.
Deeply obliged.
Obliged.
Yet, lordship, on last occasion, lordship directed me to produce that judicial order, lordship, that I have produced it, a copy of the order, lordship.
What order?
That regarding that judicial order passed by Honorable Chief Justice for listing of the cases regarding
Oh.
consideration of single benches as well as a writ appeal. And that's why we have filed an appeal that was not listed because of this lawsuit. That bench is not sitting. That special division bench.
But these are with regard to other ancillary matters,
Yes.
issues.
But this case.
Have you seen this order?
No, I haven't seen that one. But
Oh,
the way this matter, your lordship, the problem is 4 years back, the order was passed. It was directed within 2 months. Fine. If you have not done within 2 months.
you point it out before the concerned DB because
Is this matter to be posted before that bench?
we don't know. You go through the order. It says to club this and place it before a special division bench, which is
Which matter?
matters pertaining to provincialization and other ancillary issues.
Regarding provincialization.
Yes.
Here is the issue. The issue has already been decided by this court. And we are in a contempt petition. That's why I don't know whether I am correct or not, but
And we have filed an appeal that it not been listed because that
You go through the order.
yes.
You have a look at the order and then you tell us what orders. If you insist that this has to be taken up, prima facie, it appears that these matters may be required to be placed before these DB because the question of compliance, etc., are required to be not compliance, the order itself. What effect it will have in respect of these matters on the order which you are seeking compliance, we don't know today because what matters are pending.
We also don't know about.
Respondent counsel says provincialization hands off, special DB.
Provincialization, I understand, but there could be cases regarding provincialization of schools, teachers of schools which are pending or something like that. This is the case.
It says ancillary matters.
That is a very open ancillary. It can be anything.
So you have to
But
get
I
a
don't know if
clarification.
Contempt also be contempt. Otherwise, will also be.
No, contempt need not go. We are clear on that. But if the order which is sought to be complied, which has not been complied with, and against which you have filed a contempt, if these matters before the division bench, which now the division bench to be constituted will hear, if it has an effect by implication on the orders which you are seeking compliance, then it will be difficult to proceed with contempt.
Maybe your lordship is correct in that point, but if this type of orders, another similar order was also placed before the court while getting this order. If that has been already, I think, taken care of by them and implemented, then what happened to that person? If something is going to happen.
We don't know,
Something-
because the order itself says provincialization, and ordinarily it will be in respect of
Provincialization, subsequent or the earlier review.
we don't know,
order.
nothing is mentioned here. You go
Because
to the
this
order.
is on the basis of the
Give
review.
me a
order.
copy.
This is regarding all provincialization matters, lordship. Decade old.
You give him a
I
copy,
will- This
copy
is
of
with
this
regard
order.
to 2011.
We know it has not been mentioned anything. It
That is
says
why. Now, what pension, I think my learned friend be knowing more than me, in what matters are being taken up. Yes, he might have filed an appeal. I am not against that.
he's expected to know more than both of us, because his
Yes.
name is reflected in the order. So he
Yes.
appeared, so he
We have
knows.
been
So
in the panel of.
he will enlighten us.
Yes. You go through this order.
I will submit him a copy, lordship.
You go through this order, we'll take it up after a while if you want. You first have a look at the order.
I'll just get it.
Order copy to detail.
But I'll-
Yes, review. What is the review?
Review, lordship, against the order dated, lordship, page 65, lord. Personal post, lord. The petitioner was regularized against a personal post, lord.
Yes.
Lordship. In persons of order, my lord, of Madan Das, my lord, in WBC number 22714, my lord. And that this order has been passed, my lord. And the Madan Das already promoted, my lord. Although there is
Madan Das was passed in 15/9/2016.
lordship.
Dilip Talukdar was passed in 10/2/2017.
Hereafter, he was
And your order was passed on 31/10/2018.
lordship.
So Bodon Talukdar, by implication, has been overruled by Dilip Talukdar.
After this order, my lord, Dilip Talukdar's order, he was promoted.
That could be, but the
13 April 2017, my lord.
no, maybe because there is a direction of the court.
Taken care of.
There is a direction of the court in respect of Bodon Das, which was passed on 15/9/2016.
Lordship.
The division bench order came later, lord.
So now either the prima facie this order appears to be required to be reviewed.
But lordship, the junior promoted, my lord, senior is deprived. my lord.
All these things are irrelevant, Mr. Counsel. You
But
we are on
at
the
the
question of applicability of the law. On a date when the order you're relying on was passed, there was no other order.
lordship.
Subsequently, the law changed by virtue of an order of a division bench of this court. So now that division bench order will hold the field, not the earlier single bench. Not taking into account the consequence of the benefit given to the earlier petitioner pursuant to division bench order. So this order will have to be recalled.
Lordship, up to you. Up to your lordship, my lord.
Order will have to be recalled.
Sure.
Have you filed any affidavit or anything?
my
you
lord.
want to file anything? You can decide. Do you want to file any response here or raise any arguments?
Lordship, after 4 weeks, my lord, I am happy to take it.
Lordship, 651, he has not filed. lord. You have filed the review petition on
Mr.
2021.
Mubarak,
Lordship.
A. Mubarak, learned counsel for the opposite party submits, the respondent submits that he'd like to file necessary affidavit opposing the prayer for review filed by the state. He prays for 4 weeks' time. Mr. N. Upadhyay appears for the review petitioner. Matter listed, be listed after 4 weeks.
Apply.
Lordship, this contempt petition has been filed against the order dated 2010-2020.
Somebody made a mention that day
Your Lordship.
without his consent.
No, your Lordship, on that day, what was happened, I was in Arunachal bench and I have taken a consent in another matter, but my junior has understood that in this matter we have also, and both the matter has been listed before your Lordship on that. So I shall be very sorry and apologize for this matter.
No, you have to be sorry to, you express
Yes,
your
I shall be very sorry. Your
apologies to him.
Lordship.
To
Yes,
her.
your Lordship.
Yes, now, what
And-
is the order? What is the order of
At
complaint?
page 45.
45, yes.
Page 43.
Forty-five, 46.
Is the relevant portion.
What is the direction?
Your Lordship, in this case, the authorities may give final decision on the claim for compensation appointment of the petitioner. In doing so, the information provided by the mother of the petitioner as regards her occupation and income be also taken into account and thereafter pass a decision order either accepting or rejecting the claim for compensation appointment as may be applied. In the meantime, the mother has also taken VRS and is not serving at present. Such information be also taken into consideration for arriving at a written decision. Thereafter, also the bank got certain documents.
Where is the contempt here?
They need to pass an order of either accepting or rejecting.
What have you done?
Yes, your Lord. Your Lordship, this order was passed on 6/11/2020 and thereafter.
6/11.
Yes. And thereafter on 8/11/2021, the petitioner has deposited the requisites document. And thereafter, we have investigated into the matter. There is a caste difference. Whereas the father belongs to the schedule OBC.
Have you passed an order?
No, your Lordship.
When are you
Because it
likely
is
to pass an
pending
order?
before managing director, your Lord.
Huh?
It is pending before managing director.
Why?
Because all the matters has to be gone to the.
So you pass it within a fixed date.
Lordship, I have already submitted my access certificate as per by the bank. Lordship.
You
That
pass
was
it
an
within 30
imperative-
days from today.
Your Lordship, can it be your Lordship 2 months, your Lord?
45 days from the date of receipt of certificate copy. Urge learned counsel for the parties, this contempt petition is filed by the petitioner alleging willful and deliberate disobedience of this court's order passed on 6/11/2020 in WPC 8353 of 2019. By the said order, the following directions were passed. You extract the order 46, 47. So, there are learned counsel for the petitioner submits that thereafter an application was filed before the authorities concerned, competent authorities, requesting for compliance of the order by his application dated 11/8/2021. Stop. However, no orders as directed by this court was forthcoming from the competent authorities. And accordingly, this contempt petition has been filed. There are Mr. M. Sharma appears for all the respondents.
Yes, sir.
He submits that the matter is presently under consideration before the
Head office, your lord.
head office. Where is the head office? Is before the regional head.
No, it is not in regional, your lordship. As per our compensatory appointment scheme, it should be decided by the managing director, your lordship. So we have processed the entire application.
Who is the managing director and where does he sit?
Yes, sir.
Where is his seat of office? Submitted that as per the compassionate appointment scheme of the bank, all such applications are required to be decided by the managing director of the bank. And the matter is presently
Mumbai, your lordship. Nariman Point, Mumbai.
presently before the said authorities, competent authority. Stop. How much time would you require?
Your lordship, if it is
60 days is good enough.
is
We'll
good
give him
enough, your
60 days.
lordship. Yes, sir.
Mr. Sharma submits that the matter can be decided by the authorities within a short date. Upon hearing the learned counsels for the parties and upon perusal of the pleadings on record, this court considers it apposite to dispose of the present contempt petition as there was no specific time limit granted by the court in its order dated 6/11/2020 passed in WPC so and so.
Lordship, I have to again come for contempt, Lordship.
There is no contempt to begin with in the first place. We are not closing the contempt, but there is no contempt on this order. There is, in the absence of any specific directions to be complied with within a stipulated time frame. Stop. Taking note of the submissions made by the learned counsel for the bank, Mr. M. Sharma, that the matter is presently under consideration before the head office of the bank in Mumbai. Stop. Comma. We consider it. We consider it appropriate to dispose of close this contempt petition at this stage with a direction to the banking authorities to consider the application of the petitioner as directed by this court earlier by the order dated so and so, passed in WPC so and so, and pass an appropriate speaking order thereon as expeditiously as possible within the outer limit of 60 days from the date of receipt of a certified copy of this order in the office of the regional office, which is situated in Guwahati.
Yes, it is in Guwahati, MRD Road.
Within regional office. Stop. The learned standing counsel is at liberty to communicate this order to the head office. With the above observation, the contempt petition stands closed, disposed.
Lordship, as desired by the bank, Lordship, I have also submitted my access certificate on Lordship. That was obtained 6/3/2023.
Any further documents as may be required at the time of deciding the application may be called for from the petitioner, and if so done, the petitioner will file such necessary document within the shortest possible period. Yes. Yes. So what have you decided?
I have seen the order here. The order was on a particular writ appeal, which is challenging non-consideration of the provincialization in that case particularly. And now the court has given a direction that only writ petitions and writ appeals regarding provincialization should be put before a special bench, which has been constituted. That is what is there. And
Single bench, writ petitions,
All
division
single bench,
bench,
everything.
and writ appeals.
these will go.
So we have filed that appeal. That appeal is not listed because that special bench is not in sitting.
I understand.
this is
that
a
point is
contempt.
fine. This
This
is
is
a
a
contempt.
contempt. Yes.
This is a
Here
contempt.
he will have to answer why he has not come. That is his part. And that too for 4 years. Now in 4 years, you come and file an appeal and cannot take a ground on that.
What is the direction here?
Direction was to comply with within a period of 2 months. Page 17, the last paragraph.
Page 17, last para.
Para 9. I've gone through the contents of so-and-so sections of 2000, Act of 2000, and also gone through the contents of section 24 of.
Within 2 months,
Within 2 months, that's where your lordship.
you are in contempt.
Yes, that has to be drawn up. In this case,
2019.
no stay order, nothing. Now, if they think about filing an appeal after 4 years,
And
that
that
cannot
was-
protect them.
Yes.
In a
And that
contempt.
was because in a coordinated manner, lordship, that singular order or lordship was to, as per the 2011 Act, deemed provincialization lordship. Now a contradictory or judgment has been come from this honorable court. That's why, and there's also a lordship, a division bench order in the Purnamati Brahma case lordship, where the division bench held that the persons whose services were not regularized as per the 2011 Act, and after coming out of 2017 Act, their service cannot be regularized. So the division bench judgment is also there, lordship.
No, that will not come this here, your lord, in the contempt.
Lordship,
That's
let
on the
me,
merit of they should have filed at that point of time. Why they have come on now saying all these things in a
no, because
contempt
there's earlier,
Next contempt petition. lordship
earlier,
will take it
earlier
up.
respondents were lordship impleaded lordship. They were all transferred. Now they have impleaded the present respondent lordship. And service is yet to be completed so far as one of the respondent, I think, lordship, in this case.
Hmm?
In the newly impleaded respondent lordship services, I think yet to be completed. Lordship,
So another 2-3 months will go, again someone else will come. This is going on.
but that has been impleaded by this
No, but the
direction of this
newly
honorable court.
implemented is okay, but
Yes.
what has the earlier incumbents done since the date of the issuance of the direction? Have they retired?
They have not yet.
Have they
filed.
retired or what?
One is retired lordship, Pitam Sakha is retired.
Who was the secretary or
It is a-
commissioner at that relevant point in time? On 22/1/2019, who was the commissioner
That is a
secretary?
Pitam Sakha.
Pitam
was
Sakha
there,
was-
lordship.
So we'll draw up proceeding against him. Why it has not been complied with?
Yes.
Within 2 months.
At least.
There
let
is
him
a
come and
specific
explain.
direction. You
Yes.
did not file an appeal, no application for extension,
Yes.
no review.
Yes.
You are sitting on this order.
And he retired 2 years back, lordship. Already.
He may have retired. Was he in office when the order was passed on 22/1/2019?
2019,
Yes, he was-
I think 19 he was there.
Yes.
That's why he
He retired, I think, in 21.
21 or 22. you know, but-
You comply with this order. We are giving you 2 weeks time further. Comply. Or we are putting you to notice. We will issue notice, we will draw up contempt proceedings. You see, we have found that in contempt matters, you don't pray for extension of time, no review, no appeal, nothing. You just sit on the order. We can't allow you to do that. We
We have
can't allow
filed
you
that
to
appeal, but it's lately it was filed, lordship.
You have filed an appeal.
That has been filed, but it is not listed because the
No,
constitution.
no, they have filed the appeal now.
Lately it was filed, lordship.
220.
What is the order in the appeal?
No, it has not been listed
Not
because
been
the special
listed.
bench, division bench is not sitting, lordship. That is the reason.
When was it filed?
It was filed a month back, lordship. That exactly known.
How many years of delay?
That delay is there. That is there. Lordship may kindly fix it after 4 weeks. Let me take it up with the present secretary, lordship. I will take it up, lordship. The present commissioner, lordship,
I think he is not.
Heard learned counsels for the parties. This contempt petition is filed by the petitioner
Yes.
praying for drawing up contempt proceedings as the order dated judgment and order dated directions contained in the judgment and order dated 22/1/2019 passed in WPC so and so, whereby the petitioner was deemed to have been provincialized on the day the other employees were provincialized, and the respondents were directed to issue necessary orders within a period of 2 months from the date of receipt of a copy of this order.
Here, Lordship may submit, Lordship, the earlier commission has filed an affidavit, Lordship, for exemption of his personal appearance as also from this proceeding of this honorable court.
The order has not been
That was filed
complied,
on
and
27/23 February.
the petitioners have urged
Filed
that
this, Arunachal, filed one
several opportunities having been granted, the department has failed to comply with the directions of the order. Para. Mr. SMT Chisti, learned counsel for the respondent, submits that although belated, but an appeal has been filed against this order. And however, the matter is effective orders and the appeal has not yet been passed by the court. Meanwhile, he has also placed a copy of the order dated 2/6/2023 passed in writ appeal number so and so, passed by the division bench of this court, wherein the following order has been passed. Where Mr. Chisti submits that in view of this order, the special bench as directed has not yet been constituted, and consequently the appeal filed by the department has not been listed as on date. However, he submits that he be granted 4 weeks' time to complete his instructions from the department and
Present Secretary, Lordship.
take necessary steps in respect of compliance of this order. In the meantime, stop. Mr. Y.S. Mannan and Mr. U.K. Goswami, learned counsels for the petitioner, submits that this opportunity ought to be the last opportunity granted to the respondents to comply with this order. Accordingly, the matter is deferred to be listed on after 4 weeks. On 15th November. 15th November, by which time the respondent councils will update before the court the status of compliance of the order dated, directions contained in the order dated so and so, passed in WPC so and so. List accordingly on 15th.
Lordship may add one line if possible. Otherwise, now the contempt will proceed.
Yes.
Just
Which
one
line? Which?
If they do not take any step by that time.
No, last time has given.
That is already,
Yes, given.
it goes without saying because this is the contempt proceedings.
Yes. That was given.
Hopefully this time.
Let us know.
Must be.
May I please, your Lordship? Lordship, against the last office note, is deed or nor the unserved notice has not been received back.
Await service report as per office note dated 27/7/2023. List after 4 weeks.
Lordship.
await service report on respondents as per office note dated 8/8/2023. List after 4 weeks. As per office note dated 8/8/2023, petitioner has been found not to take steps on the respondents in terms of the order dated 2007/2022. Stop. Matter deferred for 2 weeks, by which time the office will make necessary endorsements in respect of the steps directed to be taken by the petitioner. List after 2 weeks.
This is the IA for impeaching the new incumbent. Right?
IA?
IA, yes.
There's an IA.
24058. The earlier principal secretary is transferred from his post. Now new incumbent has joined in this post.
Mr.
A. Boromelo.
A. Boro, learned counsel for the applicant. This is an IA 2405. Submits that the opposite party is required to be arrayed as party respondent in contempt petition number, contempt case number 680 of 2022 as a party respondent. It is submitted by the learned counsel for the applicant that the earlier incumbent of the office of Principal Secretary, Boroland Territorial Council, has demitted his office, and in his place, the present opposite party has been appointed as the Principal Secretary, and therefore his impleadment in the contempt petition is necessary, as the order dated 3/1. Which order you are seeking compliance?
122.
3/1.
Yes, sir.
3/1/2022. Passed in WPC number 7322 of 2021 has found to be is still not being complied with. Upon hearing the counsels for the parties, since this is a contempt petition, this court does not wish to issue notice on the respondent, who will in this IA seeking impleadment, as the opposite party will have to be issued notice upon impleadment in the contempt petition. Accordingly, IA stands allowed. Mr. So-and-so of opposite party is arrayed as a respondent number 2 in contempt petition number so-and-so. Stop. IA stands disposed of. Petitioner to file amended cause title in the registry. In the contempt petition, you write, in view of the order dated so-and-so, Mr. So-and-so is arrayed as party respondent number 2. Stop. Who is the person you want?
Akasdeep, my lord. Either here.
Huh?
Akasdeep.
Where have you stated in the contempt?
Here, my lord. Paragraph number 8.
You have not arrayed him, you have not reflected his name in the cause title.
Sorry, I have not reflected.
Huh?
But he is not implemented, that's why I have not reflected. But here I have.
Take some time to go through the High Court rules, the forms and procedures. His name is to be
The cause title, yes.
arrayed in the cause title as an opposite party. It is Akasdeep, IAS, Akasdeep, Principal Secretary. Yeah? Then you write in the contempt petition, in view of the order passed in so-and-so, Sri so-and-so, Akasdeep is arrayed as party respondent number 2. Petitioner will file amended cause title in the registry, and thereafter the registry will make necessary endorsements if required and place the matter after 2 weeks.
Wait, please, your Lordship. Lordship, may kindly peruse Lodgima Court order dated 25/1/2023, my lord. The respondent number 2 and 3, they have refused service of notice, my lord. Refused to accept the notice. So, therefore, presumption may be drawn, my lord.
Where is the judgment?
Judgment I have not got, my lord.
You'll have to go through the judgment.
Yes, no, I have gone through it, but have not brought it today, my lord. I should have.
On Wednesday?
Yes.
Get it. For our satisfaction, we'll
Yeah,
have to go
yes,
through the
definitely,
judgment.
definitely, my lord.
List on Wednesday.
Definitely, my lord.
Enabling
Lordship
the
is
learned
fixing it
council.
on Wednesday.
Wednesday, 27th, enabling the learned council to produce a copy of the judgment of N. Parameswar in, what is that? Nair.
Yes. Deeply.
Lozima order N. Parameswaran reported in 2017, 5 FCC 737. Yes.
Your Lordship. Lordship, it's a contempt petition by an order dated 28/3/2023, my lord.
Page number?
My lord, we come to the relevant portion, my lord. That is on page 44, my lord. Last paragraph of this order, my lord. May I read, my lord?
Yes.
Para 24, my lord. In view of the aforesaid facts and circumstances, the instant writ petition stands allowed by directing the Public Works Department to release the balance amount of ₹13,13,755 within a period of 45 days from today, following which the amount would carry interest at the rate of 12% per annum, my lord.
When was this passed?
28th, my lord, 28/3. That is on page 37, my lord. 28/3/2023, my lord.
You are not interested in the interest.
My lord.
You don't want the interest.
My lord.
You want.
My lord.
So you not earn too much of interest.
My lord.
His order was passed on 28/3.
3. My lord, even they have communicated, my lord. That is on page 49.
All right, heard learned counsels for the parties. This contempt petition has been filed alleging willful, deliberate violation of the directions contained in the order dated 28/3/2023, passed by this court in WPC number 381 of 2014. By the said order, the following directions was issued. Para 24. It is submitted that in spite of the directions to release the payment within a period of 45 days from the date of the order, the amount has not been released. Therefore, the contempt petition has been filed. You should notice returnable 4 weeks steps on the respondents by registered post AD within 2 weeks from today. List after 4 weeks.
Deeply obliged.
On the compensatory order, page 15 is the order, operative part is page 18. There's outstanding dues of 14,77,000 because they have to be paid within a period of 3 months.
The same order, I heard learned counsel for the parties, its contempt petition is filed, alleging willful disobedience of the order dated 12/5/2023, passed in WPC 1991 of 2021. Stopped by the said order, the following directions inter alia was issued. Para 5, extract. It is submitted that in spite of specific directions, the order of this court, in spite of such specific directions, the respondents failed to carry out the order of the court. Therefore, contempt petition has been filed. There I issue notice returnable 4 weeks. Steps on respondents by registered post AD within 10 days from today. Yes, Mr. Mahlon.
My lord, Lordship will find the order passed by this noble court at page 12. And my lord, operative part Lordship will find at page 15, last paragraph.
Okay. Issue notice. Order dated 23/8/2022 in WPC 3590 of 2022. Directions contained in the order. Extract from page 15, second paragraph. It is submitted that in spite of specific directions, order has not been carried out. Therefore, the contempt petition is filed. Issue notice. Returnable 4 weeks. Steps on respondents by registered post AD within 1 week from today.
Developed.
List accordingly. List after returnable date. So what did it after return?
May I please your lordships? In this case, service already been completed, lordships. Here is the case is that lordship petitioner was elected as Ancholi Panchayat president. He was removed from his office, but while removing office, violating the statutory provisions of the lordship. And outside
In view of office note dated, okay. Court has issued an order.
Lordship one on 21/2/2022, while issuing notice, court has
No, pursuant to the order of Lozima Court, has any order been passed?
No, lordship.
No order.
My period is up to 2000 December this year. Lordship.
I am asking you something, you are replying something, Mr. Counsel.
Lordship, no order passed after
Yes.
lordship.
In view of the order dated 29/5/2023, service on respondents 7, 8, 9, 10, 12, 13, 14, 15, 16, 17, 18, 20, and 21 has been deemed to be complete. Deemed to be served. In view of the order, the laws in my court, the respondents mentioned therein, notices on the respondent mentioned therein are deemed to be served properly, deemed to be served. However, none appears. Anyone for the respondents? For? No, private respondents, 7, 8, 9, 10, 11.
Private respondent number 19, your lord.
Only 19?
Only 19 appear.
Okay. It's Mr.
P. Demery on behalf of TK Dega.
Mr. P. Doimeri appears on behalf of respondent number 19. MS N. Bora for the state respondents. Mr. Borua?
I have for respondent 3 and 5.
Respondent 3 and 5. And Bora for PNRD.
PNRD 1 to 4.
And fresh steps you take on respondent number 11.
No, lordship, Lojima Code 21/7/2023 shows that is deemed service. 21/7/2023.
You have taken fresh steps.
Yes, sir. I have taken fresh steps and accordingly it was also deemed shown as deemed.
Okay. In terms of the order, as per Lozima Court order dated, as per Lozima order dated 2007/2023. Sorry, 21/7/2023. Notice is shown to be deemed to be served on respondent 11. Accordingly, notices on all respondents are deemed to be served and complete. Let the matter be listed for admission. Next week.
Next week, the date may be given, Lordship. I am paying for fixing a date, Lordship, because period is very short.
Wednesday.
Wednesday, Lordship. Oblige.
Lord,
27/9.
list after 1 week,
Why?
But
because as the term appeared this matter.
List the matter after 1 week. List on 4th of October.
4th of October.
Oblige.
Oblige.
I have received instruction in this matter. I want to file affidavit.
But why is it for orders?
Last time it's goes to Lojima Court, my lordship, regarding respondent number 6.
As per Lozima order dated 19/9/2023, Lozima Court's order, service on respondent number 6 is deemed to be complete. And accordingly, it is held that service on respondent 6 is complete. However, none has entered appearance on behalf of respondent 6. Let the matter be listed again after 2 weeks. Mr. S.R. Borua appears for respondents 1, 2, 3, 4, 5. Who appears for 7? None appears for respondent 7.
Private respondent.
It's only on respondent 6. What about respondent 7? Have you taken steps?
No order passed regarding respondent number 7, my lordship. Can you see the last order of this court on 30 June, I think, the last order. I think no order was passed.
By order dated 30/06/2023, notices were issued on respondent 1 to 6. No notice was issued on respondent 7. Accordingly, let notice be issued on respondent 7. Steps within 1 week or by registered post within 1 week from today. List after 4 weeks.
May I please, Lordship? In this matter, the stay in respect of private record, sole respondent of private record was served on 18/9, Lordship. An affidavit was filed on 29, Lordship, which is not on record. Matter may be central.
What is not there?
Affidavit in respect of dusty service of Lordship. That is not on record. Affidavit was filed on 29/2023.
Affidavit on? Dusty affidavit not filed.
Filed on 20.
Not on record.
Not on record.
It is submitted by the learned counsel for the petitioner that affidavit filed by the petitioner for taking after taking steps for service of notice on respondent 6 by way of dusty as permitted by this court by the earlier order dated 30/08/2023 has been filed. However, the same is not found on record. Matter be listed after 1 week. Registry to trace out the said affidavit stated to have been filed and connect it to the case record. M.S. N. Bora appears for the respondent, Panchayat and Rural Development.
Any date may be given and market settlement method.
Date 4th October, list on 4th October.
May I please your lordship?
Hmm.
Lordship, we are authorized to represent respondent number 3 and 4.
Who's for the petitioner? None appears for the petitioner. MS, your name. So and so appears for
Inform.
respondents number 3 and 4. Who appears and
Yes, Your
submits that she has instructions to appear for respondent 3 and 4.
Yes, your lordship. Lordship, a talk for settlement is going between the parties. We are yet to file a wakalatnama. We'll be filing it on
It
Monday.
is submitted that the wakalatnama will be filed by Monday.
May
List
this matter-
after 2 weeks.
After 2 weeks. Of pleasure.
Please, your lordship. Your lordship.
Yeah, lordship, we have complied with the order of this honorable court, lordship. Okay. This is the compliance order, lordship. The second. His service was not provincialized as his name was recommended for second post of LDA lordship. And as per the Provincialization Act, only one post of junior assistant is allowed in high school. And where one Srimati Reena Begum was holding the post.
Now she is
She has retired now.
retired. So what
The
happens
vacant
now?
post will be prescribed as per the rules, lordship. He cannot claim lordship.
But your lordship.
Only one post is.
It will have to be advertised.
Yes, lord.
Your lordship, my humble submission is that your lordship, the school has been amalgamated under the Shiksha Khetra scheme, your lordship. And your lordship, as per the notification, which I don't have at this point of time, your lordship, as per the office memorandum, your lordship, that your lordship, in regards to the excess employee, your lordship, of the high school, your lordship, because I was working as a junior assistant in the high school and as an excess employee.
So after amalgamation, what happens?
Accommodated, your lordship.
After amalgamation, what is that? What is the proposition you want to place before the court in respect of amalgamation?
Your lordship, the very issue is that, your lordship, the excess employee, your lordship, because I was an excess employee. And because of that, my.
He should be accommodated in any other school. That is his assumption.
Yes,
He can agitate in the writ. He
Yes,
can
your
challenge
lordship.
this one
Yes, your lordship.
and lordship agitate in the petition, lordship. Because being an excess, lordship, he wants his accommodation in any other school, lordship. That one.
So why don't you consider that?
That was not the direction in that petition, lordship. It was only for regarding consideration of his case. Because only one post was there in that high school, lordship. That was already been lordship holding by Miss one Reena Begum. So he cannot be accommodated, provincialized in that high school. Now he will agree by this order, lordship. He have to challenge this, lordship. And also. And direction was to that he will face a press representation that will be considered. So that representation has been considered, lordship. Page 24, last parallel. And Rule 5 of the 2018 rules prescribe that lordship, the recruitment to the post of junior assistant, library assistant, and.
No, his claim was he was asking for some relaxation.
Yes, your lordship. That was also my prayer before.
But that was not granted, I mean, by the honorable court, lordship. Honorable court has only directed him to file a representation before the commissioner secretary.
For what?
for consideration of his claim, lordships. I think that is not clear from this order, lordship. Page
If
24.
it is not clear, how did you dispose of his representation?
No, we have not. We have decided on the whole matter, lordship, because one post has already been held by one Srimati Reena Begum, and that only one post can be provincialized in a high school, lordship. In a provincialization order, lordship, that only one post has to be provincialized, and the remaining post, if any, that has to be, lordship, after her retirement, that will be filled up as per the rules. That is for the selection process has to be initiated, lordship.
Page number 23, section 33 to any constable to 80 constable.
What is Rule 33?
Your lordship, because your lordship, if there is any impediment through the imposition of the rules, your lordship, that relaxation could be imposed in a provincialized schools, your lordship, as regards non-teaching staff, your lordship. Your lordship, the court had adjudicated the matter and had also considered that if relaxation be considered, your lordship, and my application be submitted, your lordship.
What is your prayer? What was your prayer before the court?
My prayer before the honorable court was that, your lordship, for a writ in the nature of mandamus, your lordship, for a direction to consider my case for provincialization as a junior assistant.
Which can be done in view of the rules.
Yes. Yes.
The rules are very clear. It can be done.
But Rule 33 is a relaxation
No,
clause.
relaxation can be to that extent that the rule will be to the point of negating its application.
Yes, your lordship. Your lordship, then, your lordship, I would have to challenge that very speaking order, your lordship.
It is submitted, heard learned counsels for the parties. It is submitted by Mr. SMT Chisti, that the directions contained in the order dated 8/2/2021, passed in WPC 292 of 2021. Has been complied with, and by an order dated 2nd of August 2022. The application filed with the petitioner was considered but rejected.
Yes.
Stop. Copy of this order is placed before this court. Mr. T.S. Deka,
T.S. Deka, your lordship.
learned counsel for the petitioner, submits that he would like to peruse the order and complete his instructions in respect of this matter. You go through the order and decide.
Your lordship, the matter may be closed because since
Okay, he submits that the order, in view of the order dated so and so, he does not wish to press the petition any further. Accordingly, in view of this, taking note of the submissions of the learned counsels for the parties, the contempt petition number so and so stands closed.
I'm appealing for all the three, 1 to 3, lordship.
Mr. Chisti appears for
1, 2, and
respondents
3.
1, 2, and 3. Have you got a copy of the order?
Yes,
Yes,
your
yes,
lordship. I just
all are
received it,
given,
your lordship. But I'll challenge that order in the subsequent repetition, your
We
lordship.
don't know. It is for you.
Yes.
We can't give you legal advice.
Pardon me, your lordship. Much obliged, your lordship.
No objection filed.
My lord, my instructions are that, my lord, perhaps the steps on respondent number 5 is not yet complete. That's why it's come for orders today.
Who's for the petitioner?
No one appears today. It appears. Otherwise, my lord, the IA can be disposed of since it is infructuous now.
Why?
My lord, they had filed the IA praying that the temporary connection that they were enjoying be continued. Earlier, they had not paid the bills. But
what is the status of the writ petition?
My lord, in the writ petition, the respondent number 5 has not yet entered appearance. Perhaps the service has not yet been complete. And so far, the permanent connections prayer is concerned, my lord. They have not submitted the required documents to the APDCL authorities, because of which the new connection could not be given.
None appears for the petition applicant on called. Mr. Borua appears for the respondents. Which respondents?
Petition, my lord, 1 to 4.
1 to 4. List after a week.
I'm obliged.
Lordship heard this matter earlier, Lordship. He was encadered as Lordship wildlife operator from the cadre of PBX operator, Lordship, by the order dated 9 September 2010.
Yes. What happened thereafter?
Lordship, this was to be done by the government, but then it was done by the Director General. So I was aggrieved, and subsequently he was given seniority over me. So Lordship, there were 3 posts lying vacant at that point.
You are also promoted in the meantime.
Yes, Lord.
We'll take it up some other day. You are also promoted.
Yes, Lordship, but
It's only a question of seniority now.
seniority, and in 2024, I am going to retire, Lordship, but due to the delay in consideration of my promotion.
We'll take it up after vacations. List in the second week of October.
Lordship, as a matter in the top of the list, Lordship.
Yeah, top of the list.
Lies, Lordship.
Yes.
And the last occasion, Lordship was, my lord, granted time to my submit what type of, my lord, the relief is, my lord, sought for, Lordship. What type of relief is sought for, Lordship? My lord, relief is, my lord, a paragraph says, my lord, says 12, 11, my lord. 3 reliefs, my lord, have been sought for, Lordship. One is for, my lord, for setting aside the orders. My lord, cumulative effect, Lordship. That is, my lord, order dated 4/10/2012. That was, my lord, punishment imposed, my lord, reduction of, my lord, scale of pay.
We'll take it up on Tuesday. On a hearing day. What is the, why was the matter?
My lord, 65, my lord, you Lordship heard the matter only as regards, my lord, prayer, Lordship. I was not able to, my lord, submit on that day because, my lord, I was confused to which prayer is, my lord, for Lordship. 65, my lord, can you see?
65.
Yes, 65.
Yes. Yes.
My lord,
Yes.
paragraph 8, Lordship.
Reduction of pay by 2
Yes,
stages.
Lordship. Cumulative effect, Lordship, that is not in law.
You are under what? CRPF?
CRPF.
CRPF rules to some.
Rule 27, law. Rule 27, Lordship. There are many, my lord, many, as my lord, 12 punishments, Lordship. Procedure for the award. My lord, first one is dismissal or removal from service. Second is reduction to a lower time scale of pay. My lord. Second is, my lord, reduction to a lower stage in the time scale of pay, my lord. My lord, there is no, my lord, mention about, my lord, cumulative effect, Lordship. On the other hand, my lord, the effect of this reduction is, my lord, withholding increments, Lordship. My lord, increments, my lord, serial number 7. Only one stoppage of increment, my lord, single. But the punishment imposed, my lord,
Lordship, so far as this submission is concerned, my lord, the Lordship has gone through that provision, clause 2 of Rule 27. It's reduction to a lower time scale of pay, my lord, grade, post or service. But it doesn't relate to Rule 72. Rule 72 relates to, my lord, stoppage of increment, my lord. Here in this case, my lord, he was not, the punishment imposed was not the stoppage of increment. the punishment penalty that was imposed is reduction to a lower time scale of pay. So there is no specific time limit, my lord. So, my lord, my friend is harping on that rule 72.
No, 72
Yes,
holding of an increment.
yes, my lord.
1 year.
Here, my lord, we have not imposed the penalty. The
Hmm.
penalty imposed is, my lord, reduction to a lower stage of pay by,
Then
Yes.
you have added with cumulative effect.
yes, well, that I'll take a lordship to now, because rule 102, where my lord, no specific my lord, provisions are there concerning the condition of service, but then, my lord, the central government orders and rules will apply. That is what 102, rule 102 says, my lord. That means, my lord, CCA rules 1965, rule 11, 3A will apply. There, my lord, though the period is given, my lord, 3 years, but there also, my lord, I find, with all fairness, my lord, there is no provision for giving cumulative effect, my lord.
Hmm.
That's there.
On
11,
that,
11,
also, my lord,
11,
right,
3A, my lord.
agreed
It also
on.
may kindly come to that provision of CCA rules also.
CCS rules.
Yes, yes. 11, 3, Roman A, my lord.
You show us.
Yes, yes.
You show us that how the punishment can be applied, on what basis.
So far as, my lord, 3 years is
Rule
concerned.
number, rule.
Yes, yes. Rule 11, my lord.
Rule
CCS,
11.
yes. Roman 3A, my lord.
Rule 11.
Yes.
Roman 3A, reduction.
Yes. Reduction to a lower stage in the time scale of pay for a period not exceeding
It
3
says
years.
without cumulative effect.
Yes, my lord.
Now the fact that you have you have applied rule 3A.
Yes.
From what provision? From what? How are you pleading this?
Yes, my
On
lord.
what basis?
For this, further, you also may kindly come to rule 102 of the CRPF rules. my lord.
No, we find that, but
Yes.
the authorities have applied their mind and applied this rule.
Yes.
On what basis are you saying? There has to be some finding
Yes,
somewhere.
because 102 says, my lord, when there are
Mr.
specific provisions.
Counsel, 102 gives you the power.
Yes,
This power is not automatic.
yes,
There has to be an application by the authority concerned.
yes,
That in view of rule 102, we go to CCS rules and apply so and so provision. There has
Yes.
to be an order to
yes,
that.
yes.
What is available here?
So far as the records are concerned, that is not there.
Huh?
That is not.
At the first
They
line,
only say, my lord, that according to rule 27, my lord, the punishment penalty has been imposed.
We'll examine again this matter on Tuesday. You
my lord,
come
in
up
the
with.
first line, it stated that procedure was, my lord, adopted under rule 27
Yes,
of the, my lord, CRP.
Where is that first line?
My lord, the order, lordship. My page 65.
Ah.
A departmental inquiry was conducted.
Rule 11.1, section 11.1.
Section 11.1
Read with rule.
And read with rule 27.
Ah.
So, my lord, the punishment should be, my lord, within the, should be, my lord, within
On
the
what basis are you making this submission?
section, rule 27, my lord.
Correct. But you are asking for an order
Yes, my lord.
that this punishment should be interfered with.
My lord.
How are you
Yes.
making this submission? On what basis?
My lord, rule 27, there is no cumulative effect, lordship. Only one, my lord, reduction of A, my lord. What is A? A means one. But
Then you
C
file
is
an
correct.
application before the authority is concerned, seeking a review of this order. You file an application.
It may be, my lord, remanded back, my lord.
That is what we are asking you. What is the proposition? On what basis?
My lord, the train, my lord, on that day, my lord, submitted judgment, my lord. That is,
that was regarding
that was
stoppage
regards,
of
my lord,
increment.
increments anyway.
That
lord.
is,
Increment. That is not.
no, what is the purpose? What is the judgment for?
It is
As
regarding.
regards cumulative effect, lord.
Let us see.
My lord, my parent submitted on that day, lordship. He agrees, lordship. One is there, one copy is there, lord, on that one. Yeah, lordship. My lord, paragraph 12 last it is stated.
Have you read the judgment?
Lordship.
Have you read?
Lordship.
Are
Now
you sure?
paragraph 8 and 9, Lordship.
No, are you sure you have read the judgment? Or you have read only paragraph 12?
Yes, Lordship. 12 is the conclusion, Lordship.
I know, but before that, up to paragraph 11, have you read it?
My paragraph 8 is various judgments.
Have you read
discussed.
the judgment from paragraph 1 to paragraph 11?
No, Lordship.
You have not? Read it. Read it and then tell us.
My lord.
Not now. Do it
Tuesday.
on Tuesday,
Can it be on Thursday, my lord?
Thursday.
Yes.
See, you are making a proposition before law. You have to be fortified on what basis you are making this proposition.
It was submitted by my lord. And
So
trade
don't
that
rely on
level.
it if it is submitted.
And
Why
I
are you
agree.
relying on the judgment submitted by the respondents?
My lord, agreed with me, Lordship.
We are not holding a panchayat. This is the court of law. We are not sitting as a panchayat.
Yes, Lordship, on Thursday. Yes.
You are making submissions without any basis.
Lordship.
Let the matter be called up again on Thursday, 28th.
May it be my part of law?
Yeah, but what is the point in giving it part heard?
My lord, if it
You
is
are not
part of
ready
law,
to argue the matter on the basis in the manner that is required. You are placing a judgment only reading paragraph 12.
Any Lordship, my lord, if it is part of it, will be there will be private Lordship.
Don't worry about that, it will come.
Lordship.
Yes, please, your lordship. In this petitioner junior was promoted, petitioner was not promoted in his tenure of service.
Huh?
Petitioner was not promoted in his tenure of service. He was appointed as a constable during year
Who's for
after,
the respondent?
after long 20. Now he is retired from service.
He's retired.
Yes, my lordship. So,
If they filed an affidavit here,
Everybody has filed the affidavit.
affidavit already filed.
And the private respondents have also filed the affidavit.
Hmm.
And otherwise, the petitioner, he was not eligible because he did not have the education qualifications to be promoted. The private respondents were science graduates, that's why they were promoted. So we have stated that in our affidavit in detail.
Affidavit filed by?
We have filed an additional affidavit by respondent number 5 and the affidavit by respondent number 1, 2, 2, 3, 4, and 5. We have filed 2 affidavits. And the private respondents also, they have filed respective affidavits in this matter. And otherwise, the stand is very much clear with regards to education qualification. But in my humble submission, Your Lordship, the matter has become infectious because the petitioner has now retired.
How can it become? She's claiming promotion.
Promotion.
If she's entitled to that promotion, you'll get financial benefits.
But otherwise,
What do you say to the affidavits filed?
Matter may be fixed another day.
The request of learned counsel for the petitioner, matter stands adjourned. Respondent counsel, Mr. D. Bora, submits that pleadings are complete. List after 2 weeks.
This matter relates to the regularization of master role and workplace employees, my lord. And a similar judgment has also been rendered by the division bench of the Honorable Court. My lord. In this matter, you Lordship may be aware of the Upenda's judgment. My lord.
Upendas
Yes.
is not regularization.
For regularization. It may
It's
be
not regularization. You are not entitled to regularization.
Yes,
in
I
terms
know.
of-
It may be disposed of in terms of the para 22 of the judgment. My lord.
All right, heard. Anyone for the respondent? Textile. Heard. Mr. Smith, M. Smith, learned counsel for the petitioner, Mr. R. Dhor, additional senior government advocate, appearing for the respondents. The claim of the writ petitioner is for a direction to regularize his services, which he has been rendering as a master role worker since his date of appointment. In the office of the handloom Directorate of Handloom and Textile Department. Is it Directorate Office?
Yes, madam.
Stop. In spite of rendering continuous service without any blame or blemish, case of the petitioner has not been considered for regularization. Stop. The respondent number 1 and 3 has filed their affidavit contesting the claims of the petitioner. According to the respondents, in terms of government OM number so-and-so dated 16/6/2012, page number 3 of the affidavit in opposition of respondent 1 and 3, the following resolutions were taken, page number 4, extract 1 and 2. Stop. Learned counsel for the petitioner submits that in the meantime, a division bench of this court had rendered a judgment dated so-and-so passed in the case of Upendas and others. In the state of Assam versus Upendas and others. Stop. The learned counsel for the petitioner submits that he is agreeable for the matter to be disposed of in terms of para 22 of the said judgment. Stop. Para 22 of the judgment of Upendas reads as under. Extract para 22. Mr. R. Dhor, learned counsel, government counsel appearing for the respondents, does not object to the prayers made. And in that view of the matter, the writ petition stands closed, directing the respondents to carry out the directions in respect of the petitioners in terms of the directions contained in Upendas versus State of Assam versus Upendas and others.
In writ appeal number 45.
Writ appeal number 45.
Only one thing, my lord. We will verify their stand, whether it fits the judgment, my lord. And accordingly.
Before it is however made clear that before any orders are passed in terms of the directions contained in Upendas Supra, the respondent authorities are entitled to carry out a proper verification to find out if the petitioners are still entitled to the claims as prayed for. In the event they are entitled, the benefits as conferred under in terms of the directions contained in Upendas Supra be conferred accordingly. The writ petition stands disposed of in terms of the above interim order